Actually, also one motion matter will come up on Monday.
What is the matter?
Ex parte order lawsuit.
It's a motion matter.
Yes.
Okay.
Oh,
Should I get to mention your lawsuit? One matter, last got listed your lawsuit for hearing on 1/5/2000.
Hearing matters we are not taking up for 2 weeks. He'll come after vacation.
Immediately after vacation, your lawsuit.
He'll come, otherwise he'll come.
And another matter your lawsuit is on motion admission your lawsuit. WPC number 5203/2024 your lawsuit. Maybe listed on Monday your lawsuit.
Admission give it to the court master, he'll have to check it up.
Lawsuit.
We are not assuring on Monday, but he'll.
Lawsuit.
may I please, Your Lordship? I beg to mention item number 56, Lordship. Matter may be adjourned for a week, Lord.
Okay, adjournment slip was granted. Given. Okay. Item 56, both sides are represented. The pair made by counsel for the petitioner. List after 2 weeks. Okay.
Deeply, Your Lordship. May I please, Your Lordship? Lordship, I am praying for listing of an IL also.
Are you for?
I for interim is not there, so Lordship, so I am praying for the interim.
Okay, give it to the court master.
Oblige, Lordship.
Item 1 for admission.
Well, I have received the instructions yesterday. I could not file the affidavit. I prefer 2 days time. I'll file it. Otherwise, the list I have. I am required to submit the list of all 400 incumbents.
Yes.
The position of all 400 posts of Anganwadi.
To find out whether it is promotion and that the ratio has been
Upgraded.
Ah.
That list I have the copy. I could not file it. I received it yesterday.
Okay.
I prefer 2 days time. I'll file it.
Okay. We'll fix it on Wednesday then.
I'll file it. But
Mr. AZ Ahmed, counsel for the petitioner is present. Next, Mr. D. Naplan at Senior Government Advocate has submitted that as required by this court, he has received appropriate instructions and placed for 2 days time for file affidavit in opposition. Next paragraph. Accordingly, matter stands adjourned today. List again on, make it Wednesday. It's
18.
6:20.
By Monday.
We are returning to this.
Yes.
Item 2.
Lordship. Lordship, your Lordship has passed the order on 2/6/25 to take steps upon respondent number 8 and correcting the name of the respondent number 5. So, Lordship, I have taken the steps yesterday. So kindly give me 2 days time for take the matter.
Also, is represented. Next, the Illinois counsel for the petitioner has submitted that pursuant to order dated 2/6/2025, he has taken steps, which is not on record. Next, the matter stands adjourned today. List on
After 2 days. After vacation Monday.
Okay, list immediately after the ensuing summer vacation.
Online.
Upgraded item 53 for hearing. WP Criminal 26/2022.
Lordship, may kindly peruse the order dated 27/3/25. Okay, Lordship.
Oh.
Yeah. I see here. Report of the hands, report of the call to us, report.
Well, well, that report is dated, may I know the date, Mullah? On 29/4/25, a letter has been sent to me by SP that the Koheshwar Boro and Chandrajit Sharma, they have reported and they are for recording of their witnesses on 8/3/25.
9/24. 26, 9.
Okay, 3:34. So.
Plaster to. Agents pasar. Itu pasar. Satu.
Okay. 7/25. Then one of the last paragraph, as per last paragraph, Constable Ratul Roy, Rupam Borman, and Havildar Bosu Mathur.
that this is a matter, this matter is pending since 2022 before this court.
Lottie.
We'll ask the superintendent of police because he knows who are there to come.
Yes, yes,
He will make arrangements in the meantime so to produce all the witnesses before the
Lottie.
SDJM so that it can be concluded within a month.
Malur. Malur.
So whoever is left out, since we don't know the names of the witnesses who are to appear and to depose before the judicial inquiry,
Lottie.
all these people, he'll make arrangements. So
Lottie. 4 names are there in the report. Lottie mentioned these 4. If any other is left out, last paragraph 4
no,
names are there.
okay.
Last paragraph 4 names. Lottie may indicate these 4. If any other, he will take care.
Okay. Mr. Chaudhary, we are issuing a direction so that the SP can bring all the witnesses and close the matter within a month.
But
Yes. But Mr. M.H. Chaudhary, Learned Counsel, Learned Senior Counsel. Assisted by
MK Chaudhary. MK Chaudhary.
Mr. M.K. Chaudhary, Learned Counsel for the petitioners. As well as Mr. Dina, Learned Senior Government Advocate, along with Ms. M. Devi, Learned Counsel. Next paragraph. Pursuant to the order dated 9/5/2025. The SDGM within bracket M, bracket goes Gosaigaon, has sent status report of judicial inquiry. So according to this said report, on 8/4/2025, UBC Biren Chandra Ray, Chandrajit Sarma and Kohesar Boro, KUHESWAR Boro, BODO, appeared and their statement were recorded. So the statement of SI Kapil Uddin, KAPILUDDIN Ahmed, was recorded on 30/4/2025. And as per his statement, he had recorded the statement of Constable Ratul Ray, RAY, UBC Rupam Borman, Havildar Ishtiram Basumatari, KISTIRAM Basumatari, Constable Raju Ray, RAY. And accordingly, notice were issued to those witnesses and case diary of Gosaigaon PS case number 145 of 2022 was called for. Full stop. Accordingly, the matter was last fixed on 7/5/2025 for recording of the statement of Constable Ratul Ray, RATUL, RAY, UBC, Rupam Burman, Havildar, Kishtiram, KISTIRM, Basumatari, and Constable Raju Ray. It is in this report. This report will be here. Forwarding letter dated 6/5/2025. Next paragraph. Next paragraph. The inquiry, judicial inquiry relates to the alleged death of the victim by bullet injury which occurred on 18/4/2022. Subdivisional Judicial Magistrate within bracket M, bracket close, Gosaigaon is requested to expedite the inquiry. Next paragraph. We also request the Superintendent of Police English Place,
Kokrajhar.
Ukrajhar, is also requested to ensure that all the official witnesses who are required to depose in the judicial inquiry shall be produced before the subdivisional judicial magistrate within bracket M as early as possible, so that the said inquiry can be completed, preferably within a period of 1 month. Next paragraph. The registrar shall transmit a copy of this order to the SDJ, subdivisional judicial magistrate within bracket M, bracket was Gosaigaon. Full stop. The learned senior government advocate is also requested to send a downloaded copy of this order to the Superintendent of Police, Bongaigaon.
Kokrajhar.
Also Kokrajhar. Bring the order to the notice of the said authority. Two people had been killed.
Yes.
Two persons were killed.
Two people.
Not one. Killing of two persons. Next one, the report of the learned SDGM within Pegatam, like it was Gosaigaon, as forwarded by the District and Sessions Judge Kokrajhar, but forwarding letter dated 6/5/2025 is made a part of record. So in that SDGM, you also say the you made a request for early, and then say the learned SDGM within Pegatam, Gosaigaon shall send the updated status report by email to the registry, so for being placed before the court. Next para list on
Even very, no? Pardon. July, July, July. July 21,
list on 24/7/2025.
24. Gotcha. I'll let you know.
Itu with the equals only. What it should be. Any matter other than APSC matters will be adjourned today. Because
Item number 57, interim bail is till today, minor, so it may kindly be extended for a period, minor. I have 6/5.
but we
That
have a
gets an issue.
difficulty. This, after the Supreme Court order,
Yes,
we are in a difficult position.
no, that is an observation that we can renew our prayer before your lordship. So next date we'll sort it out, my lord. All
No,
this
it is
will-
for the court to take it up. You can't sort it out.
No, we can place it, my lord. What is the legal interpretation of all this? Because that is, IA is not yet disposed of, my lord. We like to accept this.
May I, with the permission of the court? My lord, here the matter has come for in the hearing column. Matter is ready for hearing. If your lordship goes to the order sheet also, many a times short time and thereafter adjourn. And we came recently with regard to the Supreme Court judgment, my lord, because it was never brought on record. So what I am on, as because it's been item number 57. And my lord, it can be heard and disposed of accordingly today itself. my lord. It won't
Perhaps
take
you are
much.
not aware, we are hearing a day-to-day matter of this APSC hearing. is
Yes, that's
being-
true. That's true, my lord.
And
That's
we
a
never-
voluminous,
And once we are hearing that,
my lord.
we really can't, we are not in a,
I understand the difficulty.
we, is beyond our capacity to,
Yes,
more.
definitely, my lord.
because you see, hearing is very easy
My
to
lord,
hear the matter.
Yes.
But the
But
Taking
then-
of a judgment.
But then we have to touch
Deliver-
this. No, delivery is also something. We have to touch this pen again.
Right.
Mr. Bhuya, we are really in a tight spot.
No issues, madam. Then let
Any
us
date.
fix a date, my lord.
You choose a date.
May I pray any date, my lord, after reopening, my lord?
You choose a date, whenever you say, we'll fix it.
21 July, my lord.
21 July, okay.
Yes, if it's convenient.
How about we'll check it out?
22.
Or
Kiba question.
Mr. Bhuya, for busy persons like you and Mr. Kamar,
I'm not
no,
busy, my
no,
lord.
no date, no date will be a convenient date. So you'll have to agree to one,
21, 22.
31.
21/7,
Right.
okay. Uh, Mr. Z. Kamar, and Senior Counsel, assisted by Mr.
S.J. Chaudhary.
Please button up your vote.
No, but it was.
Mr. S.
J. Chaudhary.
J. Chaudhary, Counsel for the applicant, and Mr. A. Bhuya, Leonard, Counsel for the respondent number,
Two, my inform.
respondent number two.
Informal.
APP will be there.
APP is not today. Because it's upgraded. I'll inform them.
Ah. Oh, okay. Who will be there as AVP?
We can call that lady, yes, Anju.
Anju.
She is holding that brief, Malik. Last time she hold the brief, she is in court number 9.
Miss
A.
A. Begum.
I'll inform her.
Okay,
Anju,
it's okay. The APP are present. Next para. As the court is in the midst of hearing of a batch of writ petitions, which is being taken up on day-to-day basis. Due to paucity of time, this matter is being adjourned today. Stop. Next para. As per observations made by the Supreme Court of India, by order dated. Just give it cap.
But
It's reflected in the order, my lord. Last order. Order dated, my lord, 2/12/2024.
2/12/2024. That the attempt to dispose the attempt should be made for disposal of the matter within 6 months. And taking note of the fact that the said order was placed before for the first time before this court by order on
2/6, my lord.
2/6/2025.
Last order.
In view of the ensuing summer vacation. List the matter on 21/7/2025.
for hearing.
Hearing is a hearing of the
It's it.
hearing along with the connected appeal. Next, till then, the interim bail passed by the order dated
2/6.
2/6/2025 stands extended till the next date of listing.
Yes.
List on 21/7/2025. Next page is made clear that matter would not be adjourned at the instance of the.
May I pray one thing, my lord? Very limited prayer. As because medical treatment is required, I have no objection with regard to this. But medical treatment for the purpose of a convict person who has preferred an appeal, my lord, earlier order was passed fixing a date so that he surrenders before the lower court below within that time, wherein he can avail he can be the guardian and avail the treatment of the minor girl. That way the trend of the order, my lord. So what I am on, my lord, let it be 2 weeks, then thereafter he surrenders, that order will serve the purpose.
But that comes between this vacation period.
Yes.
My lord, a date may be fixed within
Well,
which it is
21/6.
Honorable court, my
21,
lord.
will decide.
21 will hear and dispose it
Yeah,
of. We'll
dispose.
try
I
our
leave
best
it to your
to,
court.
we'll try our best to.
My
Yeah.
That's why it is made clear that if for some reason matter cannot be heard on 21st, 21/7/2025, just don't say that on the next date of listing, comma, the extension of the interim order would be subject to further hearing on that day.
Definitely.
List on 21/7/2025.
Madam.
Much.
But Mr. Kamal and Mr. Bhuyan, Mr. Kamal and Mr. Bhuyan.
Yes.
What is that provision of furlong and the, what you call this?
Payroll,
Payroll.
payroll.
Follow
Furlough,
under the
Can-
police act. Madam.
police act, my lord.
Ah,
There is
the
no-
prison
So
act.
can, on the next date, you also address us on this, whether we can, this bill can be converted into order of parole, or we direct the authorities
Uh,
to examine the matter for the purpose of furlong.
follow.
Furlong. These are
This,
two different concepts, my lord.
no, we understand, that's why
Yeah,
you say
yeah,
that
that's-
it is for the authorities to give parole,
Yeah, absolutely.
furlong.
Court doesn't have that.
We don't
particular-
have,
yes, yes.
but parole, perhaps you can pass an order.
Payroll after a timing with regard to the sentence being undergone, then payroll applies, my lord. Furlong is.
So
talking
address
about-
us on that next
Yes,
week. Be
I will.
prepared on that.
I will,
My
I will.
lord. Much. Obliged.
Item 3 to item 50 for hearing.
Lordship, Senior Counsel Mr. N. Kohli, he will be appearing online, Lordship. Okay,
Just intimate to
Lordship,
him,
Lordship.
because he may not be aware of the taking of the matter now. Just inform him. Okay. Mr. Mishra is making is keeping a safe distance from us.
No, no, no. I was not well. I was supposed to come because I have to reply and taken half an hour, 1 hour, half an hour.
Okay.
So I'll just give that reply after Mr. Kohli finishes. Just to clarify certain things.
Lordship may give us 5 minutes, my lords. I have requested Mr. Kohli is just joining, my lords.
Okay.
5 minutes.
So far as writ appeal number 75 of 20, like around 10, 15 days ago, I concluded my argument and I, my lord, assured that I will be giving. I have listened to Mr. Kohli's reply also. And it written, my lord, my submissions. I want to, this may be put in the concern file. I have nothing to reply more. I think this should come handy before your lordships. I distinguish my case that there was no 161 statement or 164 statement on my part. And I just cited certain decisions which your lordships will find there also. This may be put in-
You ask your assisting counsel to give a copy to Mr.
All right.
Sharma, just a copy, so that we can transmit it to Mr.
All right,
Kohli.
that will be something.
Hmm.
Obliged.
It will- 75. 75. This will be this file.
Lordship, good morning. Am I audible?
Yes, we are hearing you.
I am sorry, but my other two devices did not work, but I'm
It's okay.
fortunate
We
that my
understand.
third worked. So I think also, Lordship, I made an error of believing that you would be taking it at 2, but thankfully I did get up in time and was ready for being present before Lordship.
No, because in this case, we are sprinting against time. Not even
Now,
that.
now, Lordship, actually the right word is sprinting. Now you're doing literally, Lordship, sprinting. This is like a 10,000 meter race in which Lordship has decided to do the last lap. I'm so sorry. I apologize for the inconvenience of keeping the court waiting. It was absolutely inadvertent and unplanned. So if Lordship would permit me, Lordship, I could begin, Lordship.
Yes.
Lordship, just on a quick recap, Lordship, I have dealt with deemed confirmation, the concept of and leadership, Lordship, I both noted it, of the probationer. And in enormous detail, I have explained that the probationer, what does the law on the probationer is, right from G. Ramaswamy, Lordship, from 1964. We've dealt right up to Rajasthan High Court, Vedpriya, and so on and so forth, Lordship. Then, Lordship, where the appointment is per se illegal, or the appointee was not qualified at the time of the appointment, such an appointment is void ab initio. And Lordship, that was the whole series of judgments of Krishna Yadav, Shama Pardi, how they've been relied further. Then I've taken Lordship right up to Sachin Kumar, in which Justice Chandrachud had laid down the law. Rita Mishra, which was the Patna High Court judgment, Lordship, which also dealt with the issue of a mandamus, the scope of a mandamus, among other issues. And finally, Lordship, the last one being Naresh Kumar of Delhi. Now, Lordship, broadly, why I had done this was, Lordship, because the appellants, primarily, Lordship, what they had argued, and as I had said, subject to correction, that irrespective of whether the appellants are probationers or not, some sort of inquiry must be held with respect to the exercise of segregating the tainted and the untainted. To which our answer as the state was, Lordship, that A, the inquiry as a word cannot be read as a departmental proceeding on the nature of which the inquiry is to arrive at the objective material for the subjective satisfaction of the concerned authority, the appointing authority. So we had dealt with that. That is the objective material. So there has to be some application of mind, and there has to be something to the effect that you are able to, Lordship, apply your mind and see whether the probationer is suitable or not. Under the rules, we showed that everyone was covered under the rules as a probationer. None had been confirmed because there was no order of confirmation. So we dealt with that. Then, Lordship, the corollary to that argument of the learned senior advocates and advocates of the appellants was that there can be no reliance on the police report or investigation, which is not a substitute for an inquiry. Our answer was that the Supreme Court and the settled law is mandated that some sort of segregation should take place. And if that is done in a bona fide manner, and there is cogent material, which is objectively can be reviewed, that is enough, because police inquiry in the nature of CBI reports, in the nature of CBI investigations, all have been duly considered. So that was the other thing. Then, Lordship, a third leg was the argument on the foundational facts, as contemplated in para 40-41 of Inderpreet Singh Gehlot. And the police report, which was argued against us, forms the foundation, not the motive, thereby making the instant discharge stigmatic. Lordship will bear in mind that the argument was, don't go by the innocuous language of the corner, lift the veil and see the nature, what is the driving factor. I've showed Lordship through judgments the interchange of the use of the word foundation, motive, but what we've established through our judgments is that this was the motive, not the foundation. And without prejudice, the use of the word foundation in English language, as judgments have also used it in that context, does not mean it becomes the foundation. The police report is only the motive, which forms the basis of the objective material for the subjective acceptance or assessment by the appointing authority. These were, Lordship, the broad arguments. And what I then, Lordship, had covered was what I've already told Lordship, the following arguments. And then, Lordship, we had shown Lordship and Ladyship the rules. After showing the rules, finishing these arguments, I'm on my last leg. Now, my last leg, Lordship, is a compilation today, which, if Lordship would permit me, I think a copy is in the court. This is the compilation, Lordship, with regard to what we'll be arguing today is various judgments starting from State of Maharashtra versus R. Prabhu. And this, Lordship, will be miscellaneous. Several things will come in these arguments as I close them today. And I will also deal with the Lordship today, their arguments, and specifically their 2-3 judgments, Lordship. If Lordship is ready, then I would start.
Yes, yes.
So, Lordship, the compilation, Lordship, may note the first judgment is a 3-judge bench, Lordship, 1994, 2 SCC 481, State of Maharashtra and others versus Prabhu. Now, Lordship, this is a very interesting case, Lordship. This talks of the word social injury. And also, Lordship, and I found that very interesting, the use of the word social injury. The second aspect, Lordship, was that where a writ will not be issued when it is not in public good. A writ will not be issued when it is not in public good. These are the two main principles. Lordship, we just come to the first page, Lordship, which is para 1. It's penned by Justice Sahai, Lordship. Now, Lordship, I'm just giving a broad issue because the whole page I won't read. I'll just explain to Lordship what the conspectus was. But Lordship may come to the first paragraph. This dealt with, Lordship, section 15(2) of the Maharashtra State Board of Secondary Education Act. And the issue was, which is the second last line above placentum B, and even if it be so, then whether it was an eminently fit and proper case for exercise of discretion under Article 226 of the Constitution. Now, Lordship, what para 2 sets out is that the respondent here, Mr. Prabhu, was an invigilator, Lordship. He was a supervisor at an examination center. And in 1984, Lordship, this center, there was mass cheating, a lot of problems happened, Lordship. And thereafter, Lordship, this examination was cancelled. They were barred from resitting in the exam. They approached the writ court. Writ court said, yes, the cancellation is okay, but you can't be barred. And subsequently, Lordship, this gentleman, Mr. Prabhu, became, Lordship, appointed to the Board of Secondary Education. And that, Lordship, will find please come to placetum E. So that I'll just read from there. The Director of Technical Education, just above placetum E, on March 21st, 1985, issued a letter of withdrawing the earlier circular issued by it in view of the judgment of writ petitions. I said, Lordship, that they could resit for the exam. In March 1986, the respondent was nominated as a member of the State Board of Maharashtra Secondary and Higher Education at its Aurangabad Divisional Board. It appears that after his appointment, the university informed the government that the respondent was not a proper person to have been appointed as a member of the board, and as it was during his supervisorship that mass copying had taken place in one of the centers, and the results of the candidates who appeared from that center was cancelled. On being apprised, the government issued a show cause notice, Lordship, to him, and he, having been found to fail to have discharged his duty as a supervisor at the examination center in Nilangara, the government was of the view that his continuation as a member of the board was not conducive to the proper functioning of the board, and it proposed to remove him from the membership. Then, Lordship, we just come to the last 3 lines above placetum H. The government did not agree with the explanation that he gave, Lordship, and cancelled the membership of the respondent. This order was challenged by way of a writ petition. It was allowed, and the order cancelling the membership was quashed as ultra vires, as a plain reading of section 15(2) of the Act indicated that the government could take action only if it was of the opinion that the activities of the respondent were detrimental to or obstructing the proper functioning of the board. Therefore, Lordship, now in para 3, they have put down the Act, Lordship, which is specific to the case. Now we can come to, Lordship, below placetum D. And I'll go, Lordship, where under E it starts on the right-hand side, the word "it can legitimately be urged." I'm not getting into the explanation of the Act. It can legitimately be urged, as was attempted by the learned counsel for the respondent, that it is activities in presenti which could give rise to an action under this subsection and not what had happened in the past. Lordship, a mark, please. That is what appears to have persuaded the High Court to take the view in favor of the respondent. But what was lost sight of was that an appointment of a member who does not carry an acceptable, Lordship may mark the word, does not carry an acceptable social image in society. This is very important, Lordship, is ipso facto bad. Now, Lordship, just pausing for a minute, this judgment also will speak of social injury and social image. And I ask myself, Lordship, someone with the allegations which the appellants are facing, can they ever have a social image that would instill public confidence, public trust, if they occupy the public office funded by public funds? That's the argument, Lordship. A teacher who is expected to instill discipline in students and prepare them for future, found responsible for assisting or permitting copying in an examination center, cannot be considered to be a proper person who could have been entrusted with such duties and responsibilities as are required or discharged by the board. Induction of the respondent, who with his past records, please mark, with his past records, was undoubtedly ineligible to be appointed as a member, was detrimental to the board. It is not necessary to deal with this aspect further, as the order cannot be sustained for other reasons. Then para 4, even assuming that the construction placed by the High Court and the vehemently defended by the learned counsel of the respondent is correct, should the High Court have interfered with the order of the government in exercise of its equity jurisdiction? Now, Lordship may mark, the distinction between writs issued as a matter of right, such as habeas corpus, and those issued, is Lordship with me on the top of the page? The distinction between writs issued as a matter of right, such as habeas corpus, and those issued in exercise of discretion, such as certiorari and mandamus, are well known and explained in countless decisions given by this court and English courts. It is not necessary to recount them. The High Courts exercise control over government functioning and ensure obedience of rules and law by enforcing proper, fair, and just performance of duty. Lordship may mark the next 2 sentences are very, very important. When the government or any statutory authority passes an order which is contrary to rules or law, it becomes amenable to correction by the courts in exercise of the jurisdiction. But one of the principles inherent in it is that the exercise of power should be for the sake of justice. One of the yardstick for it is if the quashing of the order results in greater harm to society, then the court may restrain from exercising the power. Lordship, respectfully, nothing applies more to our case than what lordships have raised and laid down in this three-judge bench with regard to the social image and with regard to whether it would serve public interest. Let's see para 5, Lordship, further. On this test, the order of the High Court does not appear to be well-founded, even assuming there was a technical breach. Please mark, Lordship, even assuming there was a technical breach and the show cause notice did not spell out those relevant facts which could have empowered the government to take action, the social injury by nominating or appointing the respondent to an office of such responsibility must not only have raised the eyebrows in the educational circle, but is susceptible of creating unhealthy atmosphere. Lordship may come straight 5-7 sentences down, placentum E. Placentum E, Lordship, on page 486 on the top. Lordship, it starts with therefore, even if the order. Thank you, Lordship. Therefore, even if the order of the government was vitiated, either because it omitted to issue a proper show cause notice or it could not have proceeded against the respondent for his past activities, the High Court should have refused to interfere in exercise of its equity jurisdiction as the facts of this case did not warrant interference. What could be more harmful to society than appointing the respondent as a member of the board, a position of importance and responsibility, who was found responsible for mass copying at the examination center of which he was a supervisor? It shakes the confidence and faith of society in the system and is prone to encouraging even the honest and sincere to deviate from their path. It is the responsibility of the High Court as a custodian of the Constitution to maintain social balance by interfering when necessary for the sake of justice and refusing to interfere where it is against social justice and public. Respectfully, Lordship, this case squarely, fairly puts out what are the risks of bringing back a person with such a background, and if I may use the word now, social stigma. Not in terms of a stigmatic order, but a social stigma of such high proportions. And I would, Lordship, respectfully pray that this was all considered, placed before the learned judge, a single judge,
But
and,
Mr.
and this judgment.
Mr. Kohli, you see, we
Lordship,
for the for any person who is a delinquent and he has a disciplinary proceeding against him, which is the government thinks fit to be drawn up. So, can this judgment law be a substitute of discipline, Assam Service Disciplinary Appeal Rules, which in fact takes prescribes the procedure for drawing up proceedings against some persons?
may I assist Lordship by responding?
Yes, yes.
Lordship, 3 points there. The first is the non-applicability because they are not confirmed employees and there is no deemed confirmation. 2, they are meant for acts of misconduct in 2 circumstances. 1, a bona fide entry, and for a misconduct at the time after they joined the service. This is the entry being tainted. They are seeking the applicability of the rules prior to the period when they were born into the service, Lordship. That is the huge distinction factor. They cannot, Lordship, I will show judgments of negative equality. They cannot place themselves in the same class of persons who have a bona fide entry into the service. And they cannot, secondly, place themselves in the same class of persons asking for the applicability of the disciplinary rules for a misconduct. One side is people who commit a misconduct while discharging official functions. And this is, Lordship, respectfully, I would say a misconduct prior to their getting into the service, which means they were illegal entries into the service, which is my third argument. If your appointment is void ab initio, can you make a mockery of the entire service law by saying, Lordship, that those rules will apply to me when I shouldn't have been applied, I shouldn't have got the employment in the first place? And last, the purpose of the probation is fully justifiably, and there can be no fit case more than this to show that the purpose of the probation is fully served.
Yes.
Lordship, I hope that is my case, Lordship, for the state. And therefore, Lordship, Prabhu becomes very important in another aspect. And Lordship, I bow to what Lordship was saying, because Prabhu he's a confirmed employee. I have shown cases, Lordship, of people at that high pedestal of being confirmed, where there is no question of probation, what courts have held in the writ jurisdiction. Like Patna High Court was one example, but Prabhu basically says, Lordship, should a court in exercise of its magnificent power, and Lordship, it is the magnificent power under the writ jurisdiction, it would have to consider whether such order would serve the public good or cause social injury. Two, there's enough law on that, Lordship. The second part, Lordship, equally pertinent, is what is the infraction of the right that they are claiming, Lordship? That's critical. What infraction of what right? Respectfully, Lordship, I have dealt with the whole law on probationers. What right? They are probationers only. And they're discharged as per the rules. Now, Lordship, if they have to come before the magnificent power, invoke the magnificent power of the writ jurisdiction, there must be some right in law, in rules, that says that such a tainted entry of continuing in office. Shown a single Lordship. If Lordship is pleased, may I go to the next judgment?
Yes,
Grateful, Lordship. Now, Lordship, I'm showing the next judgment to argue what happens when there is fraud in employment, Lordship. This is, Lordship, 2013, 9 SCC 363, Devinder Kumar versus State of Uttaranchal. Lordship, I must point out that this judgment we used a lot even beyond APSC, because this one very pithily says if the foundation is weak, the superstructure collapses. And that argument I've used in law several times in other cases. So this is that one judgment which serves directly, Lordship. And I will, Lordship, go straight to para 13. Lordship, basic facts are state candidates were there was a criminal case, police person, he was removed, Lordship. But para 13 is the one that I wish to show, Lordship, straight on the law. If Lordship has para 13?
Yes.
I'm grateful, Lordship. Lordship, it says it is settled proposition of law that where an applicant gets an office, please mark this, Lordship, where an applicant gets an office by misrepresenting the facts or, and Lordship may mark, by playing fraud upon the competent authority, such an order cannot be sustained in the eye of law. Fraud avoids all judicial acts, ecclesiastical or temporal. Then, Lordship, relying on the judgment in Lazarus Estates, this court observed without equivocation, no judgment of a court, no order of a minister can be allowed to stand if it has been obtained by fraud, for fraud unravels everything. In AP Financial, Lordship may mark now, it relies on State of Maharashtra versus Prabhu. This court observed that a writ court, while exercising its equitable jurisdiction, should not act to prevent perpetration of a legal fraud, as courts are obliged to do justice. Exercising its equitable jurisdiction, should not act to prevent perpetration of a legal fraud, as courts are obliged to do justice by promoting of good faith. Equally, equity, it is known, to prevent the law from crafty evasions and subtleties invented to evade law. Then Lordship, para 15, the quoted part. Fraud and collusion vitiate even the most solemn proceedings in any civilized system of jurisprudence. It is a concept descriptive of human conduct. Para 16, in United Insurance, this court observed that fraud and justice never dwell together. And it is a pristine maxim which has not lost temper over all these centuries. Similar view in MP Mittal. Then para 17, this court held that misrepresentation itself amounts to fraud, and further held 18, a fraudulent misrepresentation is called deceit and consists in leading a man into damage by willfully or recklessly causing him to believe and act on falsehood. It is a fraud in law if a party makes representations which he knows to be false, etc. Then Lordship, para 18. The ratio laid down by this court in various cases is that dishonesty should not be permitted to bear the fruit and benefit those persons who have frauded or misrepresented themselves. In such circumstances, the court should not perpetrate the fraud by entertaining petitions on their behalf. Last sentence, Lordship, is the Tripura Sundari Devi case, Lordship. If by committing fraud any employment is obtained, the same cannot be permitted to be countenanced by a court of law, as the employment secured by fraud renders it voidable at the option of the employer. Then Lordship, Delhi Administration versus Sushil. This court examined a similar case where the appointment was refused on the post of a constable and observed, para 3, it is seen that verification of the character and antecedents is one of the most important criteria to test whether the selected candidate is suitable to a post under the state. Though he was found physically fit, passed the written test and interview, and was provisionally selected on account of his antecedent record, the appointing authority found it not desirable to appoint. Lordship, antecedent record. To appoint a person of such record as a constable to the discipline force. The view taken by the appointing authority in the background of the case cannot be said to be unwarranted. The tribunal, therefore, was wholly unjustified in giving the direction for reconsideration of the case. Please mark, Lordship. Though he was discharged, very important, Lordship, just above placentum C, though he was discharged or acquitted of the criminal offences, the same has nothing to do with the question. What would be relevant is the conduct or character of the candidate to be appointed to the service and not the actual result thereof. If the actual result happened to be in a particular way, the law will take care of the consequences. The consideration relevant for the case is the antecedents of the candidate. And then Lordship may come to para 25. The last para. Second last. More so, if the initial action is not in consonance with law, the subsequent conduct of a party cannot sanctify the same. A foundation being removed, this is what, Lordship, I've used a lot. A foundation being removed, which is sub lato fundamento cadit opus. A foundation being removed, the superstructure falls. A person having done wrong cannot take advantage of his own wrong and plead bar of any law to frustrate the lawful trial by a competent court. In such a case, the legal maxim nullus commandum capier potest de injuria sua propria applies. The persons violating the law cannot be permitted to urge that their offence cannot be subjected to inquiry, trial, and investigation. Next sentence, Lordship. Nor can a person claim any right arising out of his own wrongdoing. This also, Lordship, I would respectfully urge, squarely Kawasaki. Now, Lordship, continuing with the argument that an acquittal will make no difference. I want to go to the next judgment, Lordship, which is Union of India versus Bihari Lal Sidana, 2-judge bench, Lordship, 1997, 4 SCC 385. Acquittal by a criminal court will not give right to reinstatement. Now, Lordship, just the basic facts, I'm not reading it, para 1 to 4, is he was, Lordship, a cash clerk. And there was an allegation of misappropriation of funds in sum. So para 5 is where I wish to come straight and look at the law.
Yes.
It is true that the respondent was acquitted by a criminal court, but acquittal does not automatically give him the right to be reinstated into the service. Then Lordship may come 4 sentences down. Admittedly, below placentum A, admittedly, the respondent had been working as a temporary government servant before he was kept under suspension. Admittedly, the respondent had been working as a temporary government servant before he was kept under suspension. The termination order indicated the factum that he by then was under suspension. It is only by way of describing him as being under suspension that when the order came to be passed, that does not constitute any stigma. Mere acquittal of the government employee does not automatically entitle the government servant to reinstatement. As stated earlier, it will be open to the appropriate competent authority to take a decision whether the inquiry into the conduct is required, etc. The next sentence, Lordship, is very important. Since the respondent is only a temporary servant, the power being available under Rule 5.1 of the rules, it is always open to the competent authority to invoke the said power and terminate the services of the employee instead of, please mark, conducting the inquiry or to continue with the service of the government servant appointed accused of defalcation of public money. Reinstatement would be a charter for him to indulge with impunity in a misappropriation of public money. So, Lordship, this goes one step further than Prabhu, which is social justice, social injury, social stigma. But Lordship, this says that this would lead to further indulgence or perpetration of what the person is accused of. And second, Lordship, this also reiterates that if it's a temporary employee, you have to only act according to the rules. That right exists to discharge. Number 3, Lordship, this also, Lordship, this judgment raises the third point, Lordship, that mere acquittal will not lead to automatic reinstatement. Next judgment, Lordship, is 2020, Lordship, 3 SEC 133, P. Singara Velam versus District Collector of Tirupur, Lordship. This is on negative equality, Lordship. And I would like to go straight to the facts are not relevant so much, Lordship.
Just a moment. Which page is that?
So we'll go to, it will be Lordship. Ankit, would you just assist Lordship of the compilation page?
So next is Vipul.
Oh, I'm so sorry. I'm so sorry, Lordship. I stand correct. The Vipul is, Lordship, on my iPad. And Lordship may just excuse me. I'm going to go to read it from there, Lordship. Thank you, Ankit. I'm sorry for that, Lordship, confusion. Vipul, Lordship, is the next judgment. Now, Lordship, Vipul is 2013, 1 SEC 197. This is, Lordship, 3 judge bench, Lordship. Vipul Sheetal Prasad Agarwal versus State of Gujarat. Lordship, this was a case of default bail. And basically, Lordship, this is on the argument that further investigation will not invalidate prior investigation. Lordship may mark this because this has been vehemently argued in Manas Pratim Hollowi's matter, Lordship. I think it's writ appeal 96, Lordship. So I'm just dealing with that also. So Lordship makes straight come to para 2, 3, 4, 5 other facts, Lordship. And I will rely on Justice Chalameshwar's judgment, Lordship. So, Lordship, this had to do with the Gujarat riots and all. Lordship, that Justice Chalameshwar's judgment starts at, it's a concurring opinion, Lordship, at para 19, Lordship. And where I'm requesting Lordship to come to is para 21. May I read, Lordship?
Yes.
In my opinion, the mere undertaking of a further investigation either by the investigating officer on his own account or upon the directions of the superior police officer or pursuant to a direction by the magistrate concerned to whom the report is forwarded does not mean that the report submitted under section 173(2) is abandoned or rejected. It is only that either the investigating agency or the court concerned is not completely satisfied with the material collected by the investigative agency and is of the opinion that possibly some more material is required to be collected in order to sustain the allegations of the commission of the offence indicated in this court. Then, Lordship, 3 sentences below, after Narmada Bai versus State of Gujarat, would necessarily mean that the charge sheet submitted by the police stood implicitly rejected is without any basis in law and misconceived. So here also, Lordship, the further investigation was challenged and an argument was taken that now that the charge sheet has been filed and you've done a further investigation, that charge sheet stands invalidated or would be rejected, has been rejected by the court, Lordship. Lordship, the next judgment is Airport Authority. So, Lordship, these were on the earlier charge sheets. So, Lordship may bear in mind, in our case, there were 12 charge sheets originally. Subsequently, there was an order by the learned predecessor bench, Lordship, where we had informed the court that the SIT had been formed. Then there was the 9-page tabulation sheet, and there was fresh investigation on it, Lordship. This is all that learned senior advocate Mr. Diganta Das had argued. So in context of that, Lordship, I place this judgment, very short point, that further investigation will not invalidate the earlier charge sheets that have been filed. Now, Lordship, what is the scope of appellate proceedings has been discussed in the next judgment, Lordship, 2-judge bench 2025, 4 SCC 111. Airports Authority of India.
Just a moment. Yes, please proceed.
So, Lordship, this has been this judgment of the Airports Authority of India versus Pradeep Kumar Banerjee, Lordship, has been penned by Justice Sandeep Mehta. And it's a new judgment, Lordship, which is on the scope of appellate proceedings. Now, Lordship, the summary of facts, we can go straight to para 27, Lordship, where the discussion starts. Lordship, this man, basically Airport Authority of India, up and down, lot of proceedings. So I won't bother my Lordships with that, but we can go straight to the summary of facts, Lordship, from para 27 onwards, and para 40 is the law on the intra-court jurisdiction. May I read, Lordship, from para 27?
Yes.
So we've given our thoughtful consideration, para 28. The respondent was subjected to disciplinary proceedings on the charge of accepting illegal gratification during the course of discharge of his official duties. In view of the conviction and sentence awarded by the CBI court, Friday judgment dated 99, the inquiry was dispensed with and the respondent was dismissed from service in 2000. Aggrieved, a criminal appeal was preferred by the respondent, which came to be accepted by the High Court. Friday judgment dated 2004. Respondent was acquitted of the charges leveled against him by giving him the benefit of doubt. Thereafter, the respondent availed of the remedy given to him in the earlier round of litigation, that is to revive the challenge to the order of dismissal by filing a representation with the appellant authority. Appellant authority gave him an opportunity of personal hearing, Lordship. The order of dismissal of 2000 was set aside. However, the respondent was placed under deemed suspension with effect from 2000. Aggrieved with all this, the respondent filed a writ petition before the High Court and seeking a direction to restrain the authority from initiating fresh DP against him and quash the memorandum. Now, Lordship, I'm pausing. Why am I saying all this, Lordship, is to just point that an employee on whom there was an allegation and who had a criminal case, how he used the system in terms of multiple proceedings. And now, Lordship, may come to para 29. The appellant authority preferred a writ appeal against the aforesaid order of the single judge, which came to be allowed by the division bench, Friday order dated so and so, with the following pertinent findings: that the decision taken by the appellant authority to initiate departmental proceedings against the respondent is unassailable. The findings of the learned single judge, that in case the appellant authority is permitted to hold inquiry into the charges, it will be giving an opportunity to the employer to sit and appeal over the findings recorded by the High Court in criminal appeal decided so and so, and which was erroneous. The two proceedings, that is the criminal trial and the domestic inquiry, in which the same evidence is to be evaluated, is distinct from each other. Therefore, even if the inquiry officer comes to a different conclusion, it would not be a reflection of the findings given by the judge in a criminal trial, be that a trial court or the High Court as a court of appeal. Then Lordship, is next is on witnesses. We can come to para 40. Now, this is the law on intra-court jurisdiction, Lordship. And intra-court appeal, Lordship. Para 40. The law relating to the exercise of intra-court jurisdiction is crystallized by this court in Narendra and Company versus Workman, wherein it was held as under: once the learned single judge, having seen the records.
Yes, please continue.
Lordship, once the learned single judge, having seen the records, had come to the conclusion that the industry was not functioning after 1995 January, there is no justification in entering a different finding without any further material being placed before the division bench. The appellate bench ought to have noticed that the statement of MW3 is itself, management witness 3, is itself part of the evidence before the labor court. Be that as it may, in an intra-court appeal on a finding of fact, unless the appellate bench reaches a conclusion that the finding of the single bench is perverse, it shall not disturb the same. Merely because another view or a better view is possible, there should be no interference with or disturbance of the order passed by the single bench judge, unless both sides agree for a fairer approach on relief. Para 41. The position is thus settled that in an intra-court writ appeal, the appellate court must restrain itself, and the interference into the judgment passed by the learned single judge is permissible only if the judgment of the learned single judge is perverse or suffers from an error apparent in law. However, the division bench in the present case failed to record any such finding, and rather proceeded to delve into extensive reappreciation of evidence to overturn the judgment of the learned single judge. On going through the material, we are on record, we are of the view that the disciplinary authority, etc., Lordship, and then it says, sets it aside. Now, Lordship, I have three things to say with Lordship's indulgence. May I, Lordship?
Yes.
One is, Lordship, respectfully, a lot of arguments have been professed and in detail, and Lordships have been indulgent also, very gracious of hearing all those arguments. But respectfully, Lordship, those arguments are a repetition of what was argued and placed before the learned single judge. To a large extent, I am also, Lordship, in response to that now, placing judgments that have been relied. There are some new ones. Second, Lordship, I have not heard yet arguments to the effect what is the finding that is perverse per se. Okay. Now, the argument on the criminal part has been professed as that being a major problem. That, Lordship, stands answered by the judgments. Number three, Lordship, beyond the criminal angle, which stands answered, the law on probation remains identical, Lordship, and settled. And on that aspect also, Lordship, not a judgment has come specifically to say that a probationer in the given set of facts as us, and that's very critical, Lordship, in the identical or given set of facts deserves the interference by the writ court in a case which involves such tainted entry into service. I will deal with their three judgments, and I'm aware of Lordship Ratnesh, the Amarveer judgment, Lordship, the Joginder Pal judgment, Lordship, and the Palak Modi, and the Khatri, which is my last leg. So, Lordship, I had just wanted to place this before Lordship to
We'll take a
counter
short
Nuar.
break, come back. We'll take a short break
I'm
and come
so
back.
sorry, Lordship. I'm so grateful, Lordship. Lordship,
Just.
may I start, Lordship?
Yes.
So, Lordship, the next judgment I was looking at, Lordship, was going to place for Lordship's consideration is P. Singaravelan versus District Collector Tirupur, Lordship. This is on the aspect of negative equality, Lordship. And Lordship, this would be, I'll go straight to the law, which is on para 21. Just for my colleagues, I'll let them know the citation. Lordship is 2023 SCC 133, para 21, Lordship. Because, Lordship, several arguments have also been professed with regard to the approvers, with regards to the material, etc. So I thought, Lordship, we must deal with this also. Against this backdrop, we find, has Lordship got para 21?
Yes.
Against this backdrop, we find substance in the submission of the respondents that the appellants are not lawfully entitled to the claimed selection grade, which is a pay matter, 22. The only question to be settled, therefore, is whether the appellants are entitled to claim parity with the drivers who have so far been granted benefits vide the orders of the High Court and this court as mentioned in para 4. In this respect, we find that the High Court in the impugned judgment was correct in concluding that the appellants cannot claim such relief on the strength of Article 14 of the Constitution of India, when once it has been found that they are not lawfully entitled to the same. It is well settled by now that a person cannot invoke Article 14 to claim a benefit extended to someone similarly placed if he is not lawfully entitled to claim such benefit in the first place. Article 14 embodies the concept of positive equality alone, not negative. Equality, that is to say, it cannot be relied upon to perpetuate an illegality or irregularity. In fact, this court has opined that this principle extends to orders passed by judicial fora as well. Thus, the jurisdiction of a higher court cannot be invoked on the basis of a wrong order passed by a lower forum. In this respect, it would be fruitful to refer to the following passage from the decision of Basavaraj versus the Land Acquisition Officer. It is a settled legal proposition that Article 14 of the Constitution is not meant to perpetuate illegality or fraud, even by extending the wrong decisions made in other cases. The said provision does not envisage negative equality, but has only a positive aspect. Thus, if some other similarly situated persons have been granted some relief benefit inadvertently or by mistake, such an order does not confer any legal right on others to get the same relief as well. It is wrong if a wrong is committed in either case, it cannot be perpetuated. Equality, it is a right which cannot be claimed in illegality and therefore cannot be enforced by a citizen or a court in a negative manner. If an illegality and irregularity has been committed, then Lordship, we can leave that and therefore come to the bottom of that quoted portion, which says this proposition has been recently affirmed by a 3-judge bench. Next page, Lordship. In State of Odisha versus Anup Kumar Senapati. So therefore, I'm ending it, pausing it for a minute, Lordship. Two things to be said. One is I will argue on the approver also. It's not that I'm running away from that argument because that has been professed. But if an approver has not been discharged, they cannot say just because he or she has not been discharged, how can my discharge be upheld? That is the negative equality that they cannot claim. There is no right that they have, and hence there can be no indulgence by the court in that context. And having shown, Lordship, the law on the negative equality, I'm now going directly to the approver law. Because, Lordship, what happens when you are an approver has been settled. There are 2 judgments, Lordship. A Supreme Court, very old judgment, Lordship, of 1954, SC 616, 3-judge bench, Lordship, A.J. Paris versus State of Madras. Justice Mahajan, MC Mahajan, Chief Justice, Vivin Bose, Lordship, and Ghulam Hasan. And then, Lordship, there's a very, again, a very old 1965 judgment, Lordship, of Madras High Court, which makes very good reading. Para 9, if Lordship would be so pleased to come. The facts proved in the case do not support the first contention. The order, may I read, Lordship, para 9?
Para 9 of which case?
AJ Paris, Lordship.
AJ Paris, yes.
Yes, Lordship. It's a short judgment. Para 9. The facts proved in this case do not support the first contention. The order of the district magistrate tendering pardon to the approver was passed. Has Lordship got it?
Para 9 in the copy supplied from SCC is the only question which has been argued.
Oh, I'm so sorry, Lordship. This is... My learned colleague will just help for a minute, Lordship.
Paragraph 10, my lord.
10.
864.
Okay.
Thank you, Anna. Thank you, Anna. Ultimately, Lordship, we are all colleagues at bar. And I must say that graciously, that several, I've been the recipient of that indulgence from several of my colleagues, Lordship. The facts proved in the case do not...
And it is only between friends that you fight.
Lordship, that's a very good one, Lordship, I must say. That is very good, Lordship. Oh, what a point, Lordship. In fact,
perhaps this also can be carried forward for a healthy family life.
Well, Lordship, in this case, I would have to say on a lighter note that I can't say I do have a healthy family life with my family, but I don't have any extension in my personal case. Lordship, the facts proved in the case do not support...
11 minutes.
11. Thank you, Anna. The facts proved in the instant case do not support the first contention. The order of the district magistrate tendering pardon to the approver was passed on 28/8/1952. Albeit admitted before the district magistrate that the confessional statement made by him at Bombay, a copy of which was read over to him, was voluntarily made by him, and that he accepted it as a true statement of all that transpired in connection with the conspiracy and also the murder and disposal of the dead body of George.
Yes.
Lordship, I thought Lordship was looking for something. The next sentence is what is critical, Lordship. The district magistrate thereupon passed the order that it is a fit case for tendering pardon to him under section 337(1) of the CRPC. The objection that the tender of pardon was illegal in the absence of a formal order releasing Albert as an accused was passed was never raised before the courts below. Apart from this, we are of the opinion there is no merit in this objection. Now, Lordship may mark the key sentence that I'm relying on. We think that the moment the pardon was tendered to the accused, he must be presumed to have been discharged, whereupon he ceased to be an accused and became a witness. Now, respectfully, Lordship, that's the only thing I'm showing, is that the minute an approver is pardoned, that approver shifts from the accused box to the witness box. This is what the three-judge bench way back in 1954 is laid. And that's the law, Lordship. And therefore, that person is no longer, after due application of judicial mind, because the pardon is by a judicial magistrate, Lordship, that approver is not in the same position as a accused. Now, respectfully, Lordship, in addition to the argument of negative equality,
in the context of a criminal proceedings,
yes,
can
Lordship.
it be extended to departmental proceedings?
He's an accomplice, madam.
Lordship. So therefore, my answer is, if the person is granted, first, Lordship, a criminal proceeding is at a higher threshold because it will be beyond reasonable doubts versus preponderance of probabilities. Second, the law on approver is essentially, Lordship.
Let's take out 114. 114.
So, Lordship, the second is the law of an approver is also, Lordship, to assist the trial in reaching a logical conclusion. That is because at the end of the day, in a criminal investigation, it is an act against the state. The state prosecutes it because the act of criminality is against society at large. If a criminal act is an act against a society at large, then the state pursues it. And if to close it and bring closure and bring justice, someone needs to be pardoned, the court considers that. In the circumstance, not as a routine exercise, Lordship. Now, why am I raising this, Lordship? Not because it is my point. I am responding to the other side.
Okay.
Should the other side had the other side not raised it, I wouldn't respond to it. So two arguments come out from them raising the point.
Okay, please.
One is, Lordship, the first is A, negative equality, and the second is the law of approval. That's why I'm arguing it, Lordship. So I'm now responding. I've started shifting my focus to responding to their arguments. I have made my case so far, Lordship, which ends up to negative inequality. Now I'm responding to their arguments directly. Why? Because I will very shortly come to Khatri. I will very shortly come to the other judgments. May I continue, Lordship, on the next case? And then Lordship had asked, of course, on the departmental proceedings.
Yes.
Which is, the person stands suspended in any case, Lordship. How can somebody else say, turn around and claim equality, that you are not proceeding against them and you have proceeded against me? That's the law on negative equality, Lordship.
No.
What is the right that tells them that they can apply for that? And Lordship, in fairness, I ask myself, what is the final objective? The final objective, Lordship, is that the case may fail. And in fairness, that is the objective of anyone who's facing a trial. And everything under the book would be done, Lordship. So I can't find quarrel with that. That would be an approach of any legal practitioner for his accused client. May I, Lordship, come to the next case, which is TP Mohideen. This is, Lordship, 16th February 1965. It's a single judge, Lordship. But it makes a good reading, Lordship. Very short case. So, Lordship, coming back to the order. If Lordship will see, it is on two parts of the page, Lordship. So, on the second part of the page, on the right-hand side. Where it starts under the word order, this is a novel case.
Yes.
This is a novel case. The petitioner has filed the writ petition seeking a writ of certiorari to quash the order of the learned 7th Presidency Magistrate passed on 24th September 1964, granting pardon under Section 337 CRPC to one Gurunathan. Lordship may turn the page. Page 126. On the left-hand side column, Lordship, I'm starting with the third sentence, even an accomplice so selected. Even an accomplice so selected. Third sentence. For the award of pardon cannot be said to have obtained complete exoneration from guilt. He has to comply with the terms of the undertaking on which pardon had been granted, and in the event of his violating the undertaking, he will, at the discretion of the authorities and on certificate of the public prosecutor, be made to face a trial in the court. Actually, the provision for tendering pardon is extended even beyond the stage of investigation to the stage of trial under Section 338 CRPC, which provides that at any time after commitment, but before the judgment is made, the court to which the commitment is made may, with a view of obtaining on the trial the evidence of any person supposed to have been directly or indirectly concerned in or privy to such offense, tender or order the committing magistrate or the district magistrate to tender a pardon on such same condition as in Section 337 of the CRPC to such a person. But Section 338 is not the section to which reference is being made in this petition. The second contention of the learned counsel appearing in this writ petition for the petitioner is that Section 337 CRPC offends Article 14. Now, Lordship may mark, this is the key argument in this judgment, of the Constitution, which states that the state shall not deny to any person equality before the law or equal protection of the laws within the territory of India. There is no question in the present case of the denial of equal protection to all the accused involved in the case. It is alleged that the petitioner is the third accused in a criminal case in the court of the Session Judge Madras, where they are being charged for offences of passing of spurious gold articles as genuine gold articles. The grievance please mark lordship. The grievance of the petitioner appears to be that when there are a number of persons involved in an offence, discrimination within the meaning of Article 14 would be involved. When one is given pardon under Section 337 CRPC and the others are prosecuted. This clearly involves a misconception of the scope of Article 14. This is not a case of a failure to give protection to the accused who are prosecuted. It is a case of refraining, please mark lordship, from prosecution of the accused for certain reasons enjoined by the statute in the interests of the successful prosecution of certain other persons and getting the best evidence possible against them. It appears to me that the reference to Article 14 of the Constitution for this purpose is wholly otious. Now, lordship, it deals further several sentences, but on the right-hand side column, lordship, the last 5 lines of the first paragraph, the last 7 lines, which says further any deficit or impropriety. Further, any deficit or impropriety in the grant of pardon will be a ground on which the accused can attack the evidence of the approver as and when he gives evidence for the purpose of reducing the value of his testimony. It will be certainly no ground for quashing the order granting pardon. The result of such an order will be to put a brake in giving effect to the statutory provisions for investigation in criminal offences, and it may also serve to obstruct, please mark lordship, the course of justice. The lordship may just make a note that Section 337 is the old CRPC of 1898, and it is pari materia to Section 306 of the 1973. That is the only point, lordship. If lordship pleases, may I shift to the next judgment, lordship?
Yes.
Now, lordship, I will request lordships to keep copies of their judgment, lordship. I am going to refer to Khatri versus the state of Bihar. That is one. I'm just lordship for the benefit of the learned court master to assist lordships and ladyship. One is Khatri and others versus state of Bihar, 1981 to SCC 493. My learned senior colleague, Mr. K.N. Chaudhary, had argued this and relied upon it in great detail. The second judgment, lordship, will be Amarveer 2, which was the 5-judge of the High Court of Punjab and Haryana 2013 judgment, lordship. Amarveer 2. Then, lordship, Joginder Pal versus State of Punjab, which was the final Supreme Court judgment of 2014. Then, lordship, I'm told, my colleague just told me that Khatri is also part of the compilation. Amarveer is also part of our compilation. So, lordship may just refer to that. And then there is Ratnesh and Palak. So, Ratnesh and Palak, lordship, are not part of the compilation. So, that lordship, the learned court master may be able to assist lordship and ladyship by keeping those handy for lordship. Ratnesh Kumar Chaudhary versus Indira Gandhi Institute of Medical Sciences, Patna, 2015, 15 SCC 151. Palak, lordship, I'm not really going to rely on it because I don't think it applies to my facts, so I will deal with it in 1 minute. But Ratnesh, I will. So if lordship would be pleased, may I come to Khatri, lordship?
Page 99 of the compilation.
So, lordship, let's go to what is the internal page, 501, lordship. Now, lordship, may just make a note. This is an interesting case. It's actually a reverse of our facts. Petitioners wanted to rely on the 161 CRPC statement. The petitioners in this case wanted to rely on it, and the state resisted it. Internal page, lordship, 501. Which is para 5, lordship.
Running page 107. Yes, please proceed.
Thank you, Lordship. So, Lordship, below para 5 in the quoted of Queen Empress versus Manu, the sentence starts, the criminal court holding an inquiry or trial, which is the big paragraph on the second half of the page, middle of the page. The criminal court holding an inquiry or trial of a case is therefore empowered by subsection 2 of section 172 to send for the police diary of the case, and the criminal court can use such diary not as evidence in the case, but to aid it in such inquiry or trial. But for reason of subsection 3 of section 172, merely because the case diary is referred to by the criminal court, neither the accused nor his agent are entitled to call for such diary, nor are they entitled to see it. If, however, the case diary is used by the police officer who has made it to refresh his memory, or if the criminal court uses it for the purpose of contradicting such police officer in the inquiry or trial, the provisions of section 161 or section 145, as the case may be, of the Indian Evidence Act would apply, and the accused would be entitled to see the particular entry in the case diary which has been referred to for either these purposes, and so much of the diary as in the opinion of the court is necessary to a full understanding of the particular entry so used. Lordship may mark now. It will thus be seen that the bar against production and use of case diary enacted in section 172 is intended to operate only in an inquiry or trial for an offense. And even this bar is a limited bar, because in an inquiry or trial, the bar, please mark Lordship, does not operate if the case diary is used by the police officer for refreshing his memory, or the criminal court uses it for the purpose of contradicting such police officer. This bar can obviously have no application where a case diary is sought to be produced and used in evidence in a civil proceeding, or in a proceeding under Article 32 or 226 of the Constitution, and particularly when the party calling for the case diary is neither an accused nor his agent in respect of the offense to which the case diary relates. Now, plainly and unquestionably, the present writ petition has been filed under Article 32 of the Constitution to enforce the fundamental right guaranteed under Article 29 is neither, Lordship, very important to mark, the second sentence, to enforce the fundamental right guaranteed under Article 21 is neither an inquiry nor a trial for an offense, nor is this court hearing the writ petition a criminal court, nor the petitioners, accused, or the agents so far as the offenses arising out of their blindings are concerned. Therefore, even if the report submitted by Shri so-and-so as a result of his investigation could be said to form part of the case diary, it is difficult to see how their production and use in the present writ petition under Article 32 of the Constitution can be said to be barred under Section 172. So, Lordship, a distinction is made in the same judgment. And respectfully, Lordship, this is without prejudice to my argument that these are the arguments that the learned appellants can profess in the criminal proceedings and in any appeal connected thereon. Has Lordship got that? The paras. So, Lordship, respectfully, in several matters, the criminal trial being and arguments that may be related to that would have no bearing in the considerations, given what I have argued over these last few days, placed before Lordship in terms of the settled law. Lordship may now come to Amarveer. To Lordship. This was the second round. Lordship remembers Amarveer 1 went up to the Supreme Court. Supreme Court then said there should be an exercise for tainted, segregating the tainted and the non-tainted. This was the second full court judgment, 5-judge bench. Now, Lordship, the important point is that the first round led to Lordship, which was Inderpreet Par Kehlo. I've read 40-41, which was relied upon, Lordship. So just as a background, Lordship, this was the Punjab case in which there was issues of illegalities in appointment. There was no attempt to segregate. The whole exam was cancelled. That was the first Amarveer 1. Amarveer 1 was challenged in the Supreme Court that why are you cancelling the whole exam? You should have done an exercise of segregating. That exercise of segregation was ordered in the judgment of Inderpreet Singh Kehlo. And it was referred back to the court. After that exercise of segregation was done, came the judgment of Amarveer 2, which is what I am now going to show Lordship again. Despite the segregation, the High Court continued with cancelling the entire examination. It is, Lordship, at page 115, Lordship, of the compilation. And then comes the final judgment, Joginder Pal. Now, Lordship, two things to be made clear before I read. First, Lordship, the aim and objective in this 4 judgments was that segregation should be done. If it can be done, and the identification of the tainted has to be done. That, respectfully, Lordship, exercise we have done already. So these judgments have to be read in light of a cancellation of a complete exam without segregation and staying with the cancellation by the High Court despite the segregation, which was ordered by the Supreme Court. We've done that. Then, Lordship, I would use the word, a novel argument has been professed that there should have been a committee like a committee of the High Court which did the exercise in this case. Why do I use the word novel argument? Lordship, that committee was for segregation. It was not that a High Court committee must do the segregation. There is no such law that in every case there has to be a committee of the High Court that will do that segregation exercise, Lordship. So if the objective is segregation, who will do it is the second part. We have done that. So now, Lordship, in this background, I may respectfully read a few more paragraphs to clarify the position, Lordship. Lordship may come to para 1. Has Lordship, Ladyship got para 1, Lordship?
Yes.
Okay. So, Lordship, this may mark that this judgment shall dispose of cases of 57 petitioners who had approached the Supreme Court against the judgment of the full bench in so-and-so. Then all the judgments are, petitions are noted, Lordship. May turn the next page, second para. The following matters are for disposal which stand referred to the full bench on the remand from the Supreme Court. Para 2, or second para of the page. The following matters are for disposal which stand referred to the full bench on remand from the Supreme Court in the case of Inderpreet Singh Kehlo versus State of Punjab. The judgment.
Where is para 2?
Lordship, will be page 125.
125. On the same page, sir. Actually, it's a little back and forth.
It's 125.
125.
Running
Okay.
page.
The second pertains to
The following matter.
Above that, above that.
Above that.
the following matters. Okay.
Yes,
Okay.
Lordship. Sorry, Lordship, I wasn't there physically to assist
No, it's
Lordship.
okay. It's okay.
The following matters are for disposal which stand referred to the full bench on remand from the Supreme Court in the case of Inderpreet Singh Kehlo versus State of Punjab. The judgment and termination orders of the candidate who was set aside. 3 categories of candidates can be segregated for scrutiny. The first category pertains to the candidate who are tainted. Lordship, may just mark that this is the first category. The second category, Lordship, pertains to the candidates who are adversely affected by the process of selection being vitiated against the lute. And the third set of petitioners are those whose petitions were dismissed by the full court. Not relevant, Lordship. Then leave 1 paragraph, Lordship, 2 paragraphs, then come in the middle of the page, pursuant to the directions given by the Supreme Court. Committee of 3 judges of this court was constituted. The committee was to, please mark, separate the tainted candidates from the non-tainted candidates. So it's clear what the objective of the committee is. Turn the page, Lordship. merely showing various FIRs. Then Lordship, 2 pages later, Ankit, which page is that? 3 questions come up for consideration.
Page 129.
Thank you. Has Lordship got it? It's this just below the second para. 3 questions come up for consideration before this.
Yes, yes.
R as under, and Lordship may mark question 1. Whether 23 selected candidates, Lordship, just give me half a minute. Grateful. Whether 23 selected candidates who are facing criminal trial can be described to be tainted. Then question 2, Lordship, whether the selection, etc., whether the selection of other candidates who are not facing criminal trial can be described to be vitiated in view of the detailed investigation carried out by the Punjab Vigilance Bureau. And 3, whether the state government was fair in giving chance of second examination in 2003 to all candidates. Now, Lordship may mark question 1. The word taint, as per the new shorter Oxford English Dictionary, can be expressed to mean a trace, stain, or a blemish. It denotes some evil quality, a contaminating or corrupting influence. It can lead to mean and imbue with anything objectionable or to contaminate or infect. The word taint, when used as a verb, means dishonest, destroy integrity, vitiate, tarnish, and denigrate morally. The names of the 23 candidates against whom, please mark, Lordship, FIRs have been registered are as under. Then, Lordship, it mentions the 23 candidates against whom FIRs are there. Last sentence of the page. All the petitioners who approach the Supreme Court and against whom FIRs have been registered definitely carry a trace, stain, or blemish that they were tainted. That's all to be seen in this paragraph. Next para, Lordship. The investigation showed that candidates who had been shown favor were helped by awarding excessive marks than they deserve as compared to others by the examiners. That's all to be shown. Next page, Lordship. Second paragraph from the top. This court is not examining whether the evidence collected for recording FIR was sufficient to lead to conviction of all the candidates. The effect of the prosecution witnesses turning hostile would be considered by the criminal court where the trial is pending. Evidence being made available by the investigated agencies before the committee was sufficient to come to a conclusion that all these candidates were tainted. 23 against whom FIRs are there. The standard of proof required before a criminal court is different from the subjective satisfaction of an authority while taking an administrative decision. Please mark that, Lordship. Its standard of proof is different. The court has no hesitation to conclude that all these candidates are tainted as found by the committee and the report is accepted. That's all that I wish to show in this judgment, Lordship. Because what will become relevant is now, because I am focusing on the tainted candidates. The exercise before the Honorable High Court was segregate the tainted from the non-tainted. Now let's come to Lordship Joginder Pal and others versus State of Punjab. (145) Lordship, page 145. If Lordship has Joginder Pal, Lordship?
Yes,
I'm so grateful. Now, Lordship, we can come straight to para 14 of Joginder Pal. Lordship may only for reference see para 12 deals with the background. Inderpreet Singh Kehlo and all. But what is important is para 14 onwards.
Facts is which paragraph you said?
No, Lordship, para 12, Lordship may just note that is the background of the Inderpreet Singh Kehlo. Lordship, so the facts are the same what I mentioned. Amarveer 1, examination cancelled. Then comes Inderpreet Singh Kehlo, which Lordship is the next judgment of Supreme Court, where it asked the court to do the segregation before doing the cancellation. Amarveer 2, they did the exercise of tainted, identified 23 people as tainted who had FIRs against them. That was the judgment I read. They were held to be tainted, yet they cancelled the full exam. And finally comes Lordship, the last judgment, Joginder Pal. Has Lordship got para 14?
Yes.
Okay, Lordship, I'll read from there. After the judgment in Inderpreet Singh Kehlo, a committee of 3 judges of the High Court was constituted. Please mark, Lordship. What was the objective? After the judgment in Inderpreet Singh Kehlo case, a committee of 3 judges of the High Court was constituted with the specified task given by the Supreme Court to segregate the tainted candidates from the non-tainted candidates selected to the executive post by the PSC. The said committee undertook the mammoth and painstaking task with deep scrutiny of the case of each and every candidate. This committee submitted its report dated 2007. It is pertinent to note that the committee could achieve the task of segregating tainted candidates from the innocent candidates once, meaning thereby the committee could pinpoint the candidates who got selected were selected by oblique considerations. Pause. This mammoth task had not been done. So they were ordered by the Supreme Court, please do it. This mammoth task in our case is what is done, which is the police investigation, cogent material, objective material, which leads to the subjective satisfaction of the appointing authority. Now, reading further, it meant that others against whom no such taint was found had been selected on their own merit and performance in the written examination as well as the viva voce. This is the reason that these candidates were put in the non-tainted category. However, even when the committee was able to achieve this result, as mandated by this court in Inderpreet Singh Kehlo case, the committee also went into another aspect, namely whether it could be stated that the process of selection could be described as fraudulent, tainted, and arbitrary. Looking into the matter from this angle, the committee came to the conclusion that the entire process of selections to the premier executive post were carried out by a well-planned scheme of deception, forgery, and fraud, and therefore deserve to be set aside in their entirety. So this was the ultimate finding or recommendation. Let's come to para 15, watch. In light of this report, the original writ petitions were reheard. As a result of the remand of these cases to the High Court, as directed in Inderpreet Singh Kehlo case, matter was referred to the 5-judge bench of the High Court. The High Court has accepted the report, thereby giving its approval to that part of the report as well as which has been treated the entire selection process to be vitiated. As a result, all the writ petitions are dismissed again by a judgment of the full bench rendered on 31/5/2013. Now, Lordship, para 16. Insofar as those cases where the petitioners were found to be tainted candidates, after the scrutiny of the committee, the obvious result was that the writ petitions were dismissed on this ground. However, even in respect of non-tainted candidates, the High Court has held that it is permissible for the government to cancel the entire selection process once it is found that the process of selection itself is a result of manipulations carried out by a well-planned scheme of deception, forgery, and fraud. We will proceed to discuss the cases of the tainted and the non-tainted separately. Para 18. Tainted candidates. Now, Lordship may note the first sentence, the particulars of the candidates who are facing criminal trial. FIRs, criminal trial. Lordship, para 19. As far as these cases are concerned, they hardly pose any challenge, as is specifically found that the aforesaid persons have indulged in unfair means and have been selected either by paying bribe or because of other extraneous reasons and not on their own merit. Their writ petitions have been rightly dismissed by the High Court. This is critical, Lordship. the Supreme Court says that they are rightly dismissed, no indulgence. It is the others that the Supreme Court gets concerned with. Let's read para 20, Lordship. It was argued by Mr. Manoj Swarup, learned counsel appearing for these appellants, and those who are facing trial may be acquitted after investigation. Likewise, some of those who are even convicted, their appeals are pending, and there is a possibility that their appeals are allowed, thereby setting aside the conviction. Therefore, such a decision to terminate their services could not have been taken at this stage. Let's see what the court holds. This argument is totally unimpressive and does not hold any water. Such candidates who were selected with unfair and illegal means cannot have the audacity to say that they should be reinstated in service and allowed to continue till their appeals are decided. In any case, having found that they are tainted candidates and their entry into public service was soiled, the decision to terminate their services becomes perfectly justified. Para 22. In these circumstances, in respect of these appellants, the High Court has found that FIRs have been registered against them and they definitely carry a trace, stain or blemish that they were tainted. FIRs have also been registered, etc. Leave that, Lordship. Para 23. Again says, in this background, the High Court rightly covered these persons as tainted persons, ascribing the meaning of taint. They have reproduced that, Lordship. Next page. Therefore, all these appeals are dismissed. Please mark, Lordship, which means the tainted candidates. All these appeals are dismissed, except civil appeal so-and-so filed by one Randeep Singh, inasmuch as against him no case is registered as he is ultimately found innocent. So, Lordship, respectfully, that exercise having been done of segregation, in our case, we have done exactly that. We have not gone, Lordship, onto anything that is not what the court has laid down in law repeatedly. And Lordship, respectfully, the aspect that has to happen is basically, Lordship, to look at how can you segregate. Once having done that, Lordship, no indulgence has been granted by any court to a tainted candidate pursuant to that segregation. Now, Lordship, what I'm going to do is finish off two more judgments so that I finish the arguments of the other side. They were related to the Article 14, Lordship. So I decided to do that because there are three judgments of mine from my perspective that I will conclude with, Lordship. Janki Iyer, Rakesh Kohli, and State of Tripura. But I'll come to that last, Lordship. So because I was in the flow of Article 14 negative, then I went to the approvers, I decided to finish this, Lordship. So, Lordship, coming back to the next judgment, Lordship, is Palak. I will take a minute only on Palak, Lordship. No more, I'm not reading it, Lordship. I just wish to point out what my argument is, Lordship. Palak Modi's case, Lordship, State Bank of India and others versus Palak Modi and another. This is, Lordship, 2013, 3 SCC 607. Again, Lordship, Palak Modi was said that she got relief. Now, Lordship, the facts of Palak Modi are completely distinguishable. Completely distinguishable. Lordship, may mark, Palak Modi's entry into service was bona fide. There was no taint on her with regard to the entrance exam and her making it into service. Her cheating, if I may use that word, or her misconduct, if I may use that word, was during the confirmation written test. And so the entry is bona fide. It is not a taint at the point of entry. It is a taint at the point of the confirmation exercise. And that has no applicability to the facts of my case. Because in our case, every appellant's entry is tainted at the point of entry. The entry into service is tainted. All were probationers and there was nothing, they were all discharged prior to confirmation. And there is no exercise of confirmation which can be compared to the exercise done in Palak Modi's case. That's my point, Lordship, on Palak Modi. And this has also, respectfully, Lordship, been considered by the learned single judge. It is their part of the judgment. Now, Lordship, if I may respectfully come to Lordship, the last judgment on their side before I return to 3 judgments on mine, and then I'll close my arguments, Lordship. Ratnesh Kumar Chaudhary versus Indira Gandhi Institute of Medical Sciences, Patna, Lordship. 2015, 15 SCC 151. Now, Lordship may first make a note of my core argument. Again, the facts are distinguishable. They don't compare to our case. That's my first point. Why? Because, Lordship, in this case, a show cause notice was issued. He filed a reply and then was dismissed. The report was prepared on this basis, Lordship. Now, Lordship may just make a note what are the facts in para 1. Lordship is basically, he was a radiologist, physiotherapist, Lordship. But he was appointed to the post as a chest therapist because there was some similarity of the qualifications. Lordship, in para 2 may mark only one thing, Lordship. 4th sentence, he was put on probation for a period of 2 years. Probation for 2 years in para 2, Lordship. 4th sentence. May turn the page, Lordship. And right at the top of the page is the first sentence only. He joined the post on, Lordship may mark the date, 20th August 1999. Which is the first sentence above para 3. Appellant joined, this is relevant, Lordship, the dates. 20th August 1999. So, Lordship, in mark, he comes to the post, probation 2 years. Now, Lordship, the next paragraph becomes important. When the appellant was continuing on the post of chest therapist, a complaint was received by the Vigilance Department, Government of Bihar. Please mark the date. 3/11/2004. Lordship, that is over 5 years later. Has Lordship marked that date? 3/11/2004. Yes. Over 5 years later, relating to illegal appointment of the appellant on the post of chest therapist. Then Lordship may come just below placentum B, Superintendent of Police, it was the Deputy Superintendent of Police, who submitted a report on 3/11/2004 to the Deputy Inspector General of Police, Bihar. The reports reflected on various aspects pointed out that the appointment was illegal. On the basis of the said report, the Joint Secretary in the Department of Health, Vide order dated 9/3/2005, that's 5.5 years later, requested the director to initiate a proceeding for termination of services of the appellant by giving a show cause notice. So, Lordship, first, the facts are completely distinguishable. Para 4. Despite the request made by the appellant that all the documents were not supplied to him, which the appellant considered vital. However, he submitted his reply on 8/4/2005, and on 9/4/2005, the director terminated his services by stating that his appointment on the post of chest therapist was illegal in terms of the investigation done by the Cabinet, Vigilance Department, Bihar. So, Lordship, the facts are distinguishing. Now, para 9, Lordship. In this, Lordship, I will just make Lordship mark 2-3 sentences because these are on the facts of the case and make my argument. Para 9. So, I'll request Lordship. Para 9 says relevant.
We'll continue at 2.
I'll also, Lordship, is it already 1 o'clock? I'm so out of sync with time, Lordship. So, I'm so sorry. I didn't also keep track of it. So, Lordship may keep it at 2 o'clock. I'm grateful for that leadership. And I must, Lordship, thank Lordship and Ladyship for today keeping our matter from morning. And I'll certainly, Lordship, finish today and leave some time for my colleagues to start too. I'm making that clear, Lordship. So my friend who has come all the way from Delhi to be before
you can say it's a benevolent idea.
No, Lordship, in fact, Lordship, in fairness, We understand that Lordship is racing against time for several reasons, and Ladyship also is there. And therefore, Lordship, we have cut out many paragraphs and several judgments because we feel there's no point to labor if we are making the point in limited. I'm so grateful for Lordship's indulgence.
Just a moment.
If it may please, Lordship. So, Lordship, Ladyship, I was on Ratnesh. And after finishing Ratnesh, with Lordship's permission, I will show 3 judgments to bolster another point and make my closing arguments. I will also, Lordship, in fairness, distinguish one particular case. I forgot about that. Is writ petition 96, which Mr. Diganta Das, Learned Senior Counsel, had argued in great detail. So, Lordship, we were on para 9. In Ratnesh, Lordship.
Yes.
Lordship, may just 2-3 sentences I wish to show in para 9, and I'll make my argument and proceed further. So, Lordship, para 9 deals with the vigilance report of 2004. And Lordship may note just below placentum C, it says directed to take action against him. His work being unsatisfactory, many warnings were issued to him. Explanations were called and punishment was given. Now, why this is relevant? Non-applicability of facts, Lordship. Then Lordship may just come between placentum D and E, where in the middle of the page is the word establishment, after which the sentence, as well as the order of punishment of withholding his 2 annual increments with cumulative effect was passed by the institute for his indiscipline in service, and warnings were issued that if in future any complaint is received, then his services may be terminated. So pause, Lordship, on the facts to close it. He's appointed, being a physiotherapist, he's appointed as a chest therapist. 5.5 years later, a complaint comes. This is the background in which there's a vigilance report. He's terminated. Now, Lordship, we must mark. So I wish to distinguish this, that there is no such report in our case which was relied upon. I mean, no warnings given to the candidate, nothing. The facts are totally different. Ours is a case of simpliciter dismissal of a probationer on the basis of the information received through the police report or the investigation, which was the objective material used for the subjective satisfaction with regard to their continuance or confirmation eventually. And we then discharge them under the rules. Here the show cause notice, reply, termination to someone who joins in 1999 and is terminated in 2005. That's 5.5 years later. So that's a very, very critical distinguishing factor, Lordship. Now, Lordship may come to para 13 for a minute.
Paragraph
13, Lordship. Just, Lordship, it was their submission. I'm not reading it. I'm merely, Lordship, informing Lordship that this is their submission. Now, Lordship may come to para 19. Just so that, Lordship, I'm not accused later on that this submission should have been considered while I was distinguishing the case. Para 19 is important, Lordship, and then 27. This will require some reading, Lordship. 19. After stating,
Yes.
19. After stating the asset principle, the court traced the history and referred to Anup Jaiswal, so and so, and opined as follows. And then Lordship quotes the Radheshyam Gupta case, para 33, which is what I'm reading. It will be noticed from the above decisions.
Yes, please continue.
Yes, Lordship. It will be noticed from the above decisions that the termination of the services of a temporary servant or one on probation on the basis of adverse entries or on the basis of an assessment that his work is not satisfactory will not be punitive as such, as the above facts are merely the motive and not the foundation. The reason why they are the motive is that the assessment is not done. This is very critical, Lordship. That the assessment is not done with the object of finding out any misconduct on the part of the officer, as stated by Justice Shah, as he then was. It is done only with a view to decide whether he is to be retained or continued in service. The position is not different, even if a preliminary inquiry is held, because the purpose of the preliminary inquiry is to find out if there is a prima facie evidence or material to initiate a departmental inquiry. Confirmed employee lordship. It is also so decided in Champaklal's case. The purpose of the preliminary inquiry is not to find out misconduct on the part of the officer, but if a termination followed without giving an opportunity, it will not be bad. Even in a case where a regular departmental inquiry started, a charge memo issued, reply obtained, and an inquiry officer is appointed, if at that point of time the inquiry is dropped and a simple notice of termination is passed, the same will not be punitive because the inquiry officer has not recorded evidence nor given any findings on the charges. That is what is held in Sukh Bahadur case and Benjamin case. In the latter case, the departmental inquiry was stopped because the employer was not sure of establishing the guilt of the employee. In all these cases, the allegations against the employee merely raised a cloud on his conduct. And as pointed by Justice Krishna Iyer in Gujarat Steel Tubes case, the employer was entitled to say that he will not continue an employee against whom the allegations were made, the truth of which the employer was not interested to ascertain. In fact, the employer, by opting to pass a simple order of termination as permitted by the terms of appointment or as permitted by the rules, was conferring a benefit on the employee by passing a simple order of termination, so that the employee would not suffer from any stigma which would attach to the rest of his career if a dismissal or other punitive order is passed. The above are all examples where the allegations whose truth has not been found and were merely motive. Pausing for a minute, Lordship, in some of the judgments that I have relied upon earlier, Lordship, even FIR, in one of the judicial officers' cases, the kind of comments that were there, he's so and so, he's so and so, that also was not held to be stigmatic. So, I mean, I'm just showing the different layers or levels at which, Lordship, and in our case, it is purely and purely only the motive, not the foundation. Nor will the use of a word, an English language word, foundation, in an affidavit change the nature of the exercise. Because all the judgments show, for it to be the foundation, it's a different level required. Para 34, Lordship. But in cases where termination is preceded by an inquiry and evidence is received and findings as to misconduct of a definitive nature are arrived at behind the back of an officer, and where on the basis of such report, the termination order is issued, such an order will be violative of the principles of natural justice inasmuch as the purpose of the inquiry is to find out the truth of the allegations with a view to punish him and not to merely to gather evidence for a future regular departmental inquiry. In such cases, the termination is to be treated as based or founded upon misconduct and will be punitive. And this is not specific to a probationer, Lordship. These are obviously not cases where the employer feels that there is a mere cloud against the employee's conduct, but are cases where the employer has virtually accepted the definitive and clear findings of the inquiry officer, which are all arrived at behind the back of the employee, even though such acceptance of findings is not recorded in the order of termination. That is why the misconduct is the foundation and not merely the motive in such cases. Having read this, Lordship, cleared what has been held in this, let's see what para 27 then says or states. Para 27, Lordship. And I will read this carefully, Lordship, particularly the last sentence on this page. In the case at hand, it is clear as crystal, and on the basis of a complaint made by the MLA, an inquiry was decided to be held. It has been innocuously stated, para 27, Lordship. The third line, it has been innocuously stated that the complaint was relating to illegal selection on the ground that the appellant did not possess the requisite qualification and was appointed to the post of chest therapist. The report was then submitted to the Cabinet Vigilance Department. Eloquently states about the conduct and the character of the appellant. The stand taken in the counter affidavit indicates about the behavior of the appellant. It is also noticeable that the authorities, after issuing the show cause notice and obtaining a reply from the delinquent employee, did not supply the documents. Be that as it may, no regular inquiry was held and he was visited with the punishment of dismissal. It is well settled in law if an ex parte inquiry is held behind the back of the delinquent employee and there are stigmatic remarks that would constitute foundation and not the motive. Therefore, when the inquiry commenced and thereafter, without framing of charges or without holding an inquiry, the delinquent employee was dismissed, definitely there is a clear violation of principles of natural justice. Pause, Lordship. Before I highlight what I wish to highlight, just one sentence as a submission. We have not held any such inquiry, Lordship. First, it is in the given facts of this case, Lordship. All the files of each appellant was placed before the learned single judge, Lordship, who did not find any reason to hold that the discharge is based on a foundation and not a motive. The whole idea of placing their files, Lordship, their individual files, was for the court to ascertain whether it was the motive or the foundation. After going through each file, this court has held that it is not the foundation, it is the motive, and therefore there is no violation of principles of natural justice. Now, Lordship may mark the next sentence, which is critical to me. The last word on this page, it. And turn the page, Lordship. It cannot be equated with a situation of dropping of the disciplinary proceedings and passing an order of termination simpliciter. In that event, it would have been motive and could not have traveled to the realm of foundation. So even Ratnesh, Lordship, I will respectfully argue, helps us. Ratnesh does not mitigate against any of the arguments of the state, Lordship. In fact, I am relying on this specific. Lordship, having dealt with Ratnesh and their judgments, Lordship, if Lordship would be pleased if I can just quickly now for my last three judgments, Lordship, which is in my compilation, Lordship, judgment number 9, S. Janki Iyer versus Union of India, 2025, Lordship. This is on the principles of violation, natural justice, violation of principles of natural justice.
870.
Now, basically, Lordship, finally, in this, the doctrine of empty formality will again get reiterated, Lordship. Basic facts are, Lordship, just to bear in mind that there was non-supply of a report or to a confirmed employee. That is the relevant thing that Lordship may be pleased to note. The non-supply of the report. Para 19, Lordship. Has Lordship got that?
Yes.
The aspect with regard to non-supply of the copy of the preliminary inquiry report again would not hold for long for the simple reason that it was, please mark Lordship, never made the basis for coming to a conclusion in the regular departmental inquiry with regard to the guilt of the appellant. It is an admitted fact that after the preliminary inquiry, charge sheet was issued to the appellant and thereafter a regular departmental inquiry was held where both the parties had led their respective evidence and on the basis the inquiry officer had returned his findings. He's a confirmed employee. 20. The principles of natural justice are founded on three fundamental rules that ensure fairness in legal and administrative proceedings. Firstly, the hearing rule. I quite like the way they put it here, Lordship. Firstly, the hearing rule, odi alternum partem, which mandates that no person should be judged without being given a fair opportunity to present his case. Secondly, the bias rule, nemo judice in causa sua, which asserts that no one should act as a judge in his own case, thereby safeguarding impartiality and preventing any form of bias. And lastly, the principle of reasoned decision, also known as the speaking orders, requires every decision to be supported by valid and clearly stated reasons to promote transparency and accountability in the decision-making process. Para 21. No prejudice having been caused because of the non-supply of the preliminary inquiry report to the appellant, the plea of violation of principles of natural justice would not be available to the appellant. As a matter of principle, violation of the principles of justice cannot be on the touchstone of, mark please Lordship, technical infringement, made the basis for setting aside the decision by the authority against an employee unless it is established, Lordship established, that grave prejudice has been caused to an employee because of non-supply of a particular document. Pause, Lordship. In another judgment, the word used was real prejudice. That has to be established by them, which is where the doctrine of empty formality came. Para 24, Lordship. A constitution bench it relies on, Lordship. The position, because they also rely, I'm told, on this, Lordship. So let's look at what Para 24, that judgment says. The position of law in this aspect has been culled out by the Constitution Bench in the Supreme Court in the case of Managing Director ECIL Hyderabad versus B. Karunakar, followed and explained thereafter by this court, expounded the doctrines of reasonable opportunity and natural justice to have been conceived and evolved not as a mechanical or ritualistic formality, but as, and Lordship may mark, substantive principles intended to safeguard the rule of law and to facilitate the assertion of legitimate rights by individuals. It was categorically held that these principles are not to be invoked as mere procedural sacred words that have the magical effect when said on every occasion, irrespective of context. The court underscored the aspect as to whether prejudice has in fact been occasioned to an employee by the non-supply of the inquiry report, which must be assessed with reference to the specific facts and circumstances of each case. Upon such assessment, if it is evident that no different outcome would have emerged even after the inquiry report or documents had been furnished, to reinstate the employee and grant him consequential benefits in such situation would amount to a distortion of justice. In other words, it would amount to conferring a premium upon misconduct and to stretch the doctrine of natural justice to an illogical, unwarranted extent. Such an expansive and indiscriminate application of the principle would paradoxically undermine the very concept of justice it seeks to hold. Lordship, it is so eloquently said, I really can't add anything further to that. Now, Lordship, I will show the next judgment, Lordship, which is Rakesh Kohli, Lordship. Rajesh Kohli. This is, Lordship, 2010, 12 SCC, 783, two-judge bench, Lordship, Rajesh Kohli versus the High Court of Jammu and Kashmir. So, Lordship, just para 1 for the basic facts, Lordship. If Lordship Ladyship has para 1. The present writ petition has been filed by the petitioner under Article 32 of the Constitution of India against the impugned administrative order of the High Court of Jammu and Kashmir, Respondent 1, recommending the termination of the services of the petitioner, and Lordship may mark, who was working as a probationary judicial officer, and also against the order issued by the state of Jammu and Kashmir dispensing with the services of the petitioner as a district and sessions judge. Now Lordship may come to para 6. Para 4, Lordship may just mark the first sentence. He was also given increments. Because this argument has come, Lordship, I got my increments, I did my training, etc. Para 6. The aforesaid report of the Registrar Vigilance dated 2001 was placed before the Chief Justice of the Jammu and Kashmir High Court, who directed that the matter be referred to the Chairman Disciplinary Committee for necessary action. The Registrar Judicial of the High Court was asked to file a criminal complaint against the petitioner before the SHO of the police station concerned. Para 11. Now, this argument, Lordship, that is professed by the petitioner herein is almost exact to what has been argued by the appellants before Lordship. The petitioner, para 11, the petitioner also submitted. May I continue, Lordship?
Yes, yes.
Para 11, the petitioner also submitted that his service was terminated on the ground of an alleged misconduct, namely pendency of a criminal complaint and his alleged behavior with subordinate staff, and therefore the said order of termination of service was in the nature of a punishment by casting a stigma on the petitioner, and therefore illegal and without jurisdiction, as no opportunity of hearing was given to the petitioner prior to passing of the order of his termination. He also submitted that since he was granted increments by the respondents, it is proved that the respondents were satisfied with his service, and therefore the order terminating his service is without jurisdiction. In para 16, Lordship may just mark that they rely on Satyanarayan Athya versus the High Court of Madhya Pradesh. So we are, Lordship, now in 2010. Satyanarayan Athya, Lordship, I have already read. Para 18. Para 18 deals with the purpose of probation, Lordship. During the period of probation, an employee remains under watch and his service and his conduct is under scrutiny. Around the time of completion of the probationary period, an assessment is made of his work and conduct during the period of probation, and on such assessment, a decision is taken as to whether or not his service is satisfactory, and also whether or not, on the basis of his service and track record of his service, should be confirmed or extended for further scrutiny of his service, if such extension is permissible, or whether his services should be dispensed with and terminated. The services rendered by a judicial officer during probation are assessed not solely, and Lordship may mark this, not solely on the basis of judicial performance, but also on probity as to how one has conducted himself. So probity is an important aspect for consideration, Lordship, not just of a judicial officer, but of anyone in public employment. Para 22. In our considered opinion, none of the aforesaid two orders could be said to be stigmatic order, as no stigma is attached. Of course, the aforesaid letters were issued in view of the resolution of the full court meeting, where the full court of the High Court held that the service of the petitioner is unsatisfactory, whether or not the probation period could be or should be extended, or his service should be confirmed, is required to be considered by the full court, in our case, the appointing authority. And while doing so, necessarily the service records of the petitioner are required to be considered. And if from the service records it is disclosed that the service is not satisfactory, it is open for the respondents to record such dissatisfaction regarding his unsatisfactory service. And Lordship may mark, and even mentioning the same in the order, please, Lordship, even mentioning the same in the order would not amount to casting any aspersion on the probationer, nor could it be said that stating in the order that his service is unsatisfactory amounts to a stigmatic order. Para 25. In Krishna Devaraya Educational Trust versus Balakrishna, the services of the respondent assistant professor were terminated on the ground that on the ground of job proficiency was not up to the mark. This court held merely a mention in the order by the employer that the services of the employee are not found to be satisfactory would not amount to the order being a stigmatic one. 5. There can be no manner of doubt that the employer is entitled to engage the services of a person on probation. During the period of probation, the suitability of the recruit appointee has to be seen. If his services are not satisfactory, which means that he's not suitable for the job, then the employer has a right to terminate the services as a reason thereof. If the termination during probationary period is without any reason, perhaps such an order would be sought to be challenged on the ground of being arbitrary. Therefore, naturally, services of an employee on probation would be terminated when he is found not to be suitable for the job for which he is engaged, without assigning any reason. If the order on the face of it states that his services are being terminated because his performance is not satisfactory, the employer runs the risk of the allegation being made that the order itself casts a stigma. We do not say that such a contention will succeed normally. Therefore, it is preferred that the order itself does not mention the reason why the services are being terminated. So, Lordship, in this case, it was unsatisfactory. Now, if we are saying, Lordship, that the termination is on the basis of the police investigation, that if we were to even say that in the order, per se, it would not ipso facto become a stigmatic order. That was the point, Lordships, we were placing. Now, Lordship, to the last judgment that I wish to come to is of the Agartala bench, Lordship, of this Honorable Court. State of Tripura and others versus Krishna Kanta Dev Burma. Lordship, may just see the head note of this judgment, Lordship. I normally don't read the head notes, but this just states the facts very pithily. This is, Lordship, 2007, 3 Guwahati Law Reports, 55.
Page 91 it starts.
Once Lordship has it, and Ladyship, I'll read.
Yes, yes.
Lordship, labor and services termination, petitioner on probation and in temporary service. Petitioner is undergoing training. Petitioner remained absent from training unauthorizedly. Detailed report regarding the unauthorized absence furnished by the principal of the training college to the superintendent of police. Petitioner is discharged from service as per rule so and so on the conduct of the petitioner, which according to the appointing authority was serious and detrimental for discipline in the police force. Order not stigmatic and punishment, but an order of termination simpliciter. Single judge set aside the termination order, upholding the same to be punitive. On appeal, judgment of the single judge has been set aside. So para 4 is just the basic fact what I just read, Lordship. Not required to be read, Lordship. Para 8.
Yes.
In fact, Lordship, I can also, if Lordship pleases, point out that this is the principle on which it is there. But let Lordship know that the paras are basically 4, 8, 9, 14 and 16. Para 4, 8, 9. Then Lordship 14 and 16. I'm merely showing it, Lordship, of what this Honorable Court has held. The principles remain the same, Lordship.
Yes.
Now, Lordship, having dealt with all the judgments, I would wish to come to the affidavit in opposition of Manas Pratim Haloi, writ appeal 96 of 2022, Lordship. So I will request Lordship if would have our affidavit in opposition of writ appeal number 96 of 2002.
Writ appeal 96.
Yes, Lordship. Manas Pratim Haloi.
I mean, writ appeal 96.
While Lordship it is coming, I may just assist Lordship. This is the client, this is the appellant whose case was argued by learned senior advocate, Mr. Diganta Das. And Mr. Das has, in great detail, argued on the 9-page tabulation. He's argued about the further investigation, raised questions on the charge sheet, and several things related to that, Lordship, in great detail. What I'm placing before Lordship is what the state has on its affidavit already stated. Some paras I'm going to read. And then Lordship requests Lordship to mark one paragraph, which is more detailed, because we've dealt with this case specifically in detail in our affidavit in opposition. So once Lordship has the affidavit in opposition, I'll just show Lordship the relevant pages.
That will be today's list, which will be the item,
Item 45, Malad.
item 45.
Item 45.
And after this, Lordship, I will then make my concluding remarks.
45. Kita went to get look. Trying to keep on late for us. 45.
While Lord, Lordship, while that is coming before Lordship and Ladyship, may I in the meantime make a submission on the sealed cover argument?
You have got the records.
Wonderful, Lordship. Then we'll start with this. I'll do the sealed cover after that, Lordship. I don't want it to be said that I did not allow it to go unrebutted. Now, Lordship, may please come to para number 4, which would be on running page 726. Para 4 on 726, Lordship, Ladyship. May I read, Lordship?
Paragraph?
4 at 726, Lordship.
Paragraph 4.
Yes, Lordship.
I think there's some.
My copy, it's the internal page 3 of the affidavit in opposition, Lordship.
You can renumber your copy. It will be 722.
720.
Paragraph 4 is at the threshold.
Yes, Lordship. So it's 722. I'm grateful for that, Lordship. I'll just minus 4 when I next request Lordship to turn the page to the next page.
Yes.
So, Lordship, at the threshold, it is most respectfully submitted that the appellant herein deserves no indulgence from this honorable court, particularly in light of his conduct as is evident hereinafter. The appellant herein had initially filed writ petition criminal 30 of 2021. Lordship, that is still alive today. It is not disposed of. It is there before the honorable court. The appellant herein had initially filed writ petition criminal number 30 of 2021, wherein he has sought to raise questions on the investigation as well as on the investigating officer, and pleaded to the effect that the investigation in the instant case had been undertaken in a selective and motivated manner to shield the real beneficiaries. Subsequently, in the present appeal, and Lordship may mark this also, I have personally gone through this myself. The appellant has virtually copy and pasted substantial paragraphs from writ appeal criminal 30 of 2021 into the present appeal, in effect seeking simultaneous adjudication on identical contentions by 2 separate benches of this honorable court, the learned single judge and the division bench. So my first point is, Lordship, everything said about the investigative officer, his transfer and postings, Lordship, several transfer postings take place of several officers. on a regular basis. There is no order saying that he has done a bad investigation. His investigation is relied upon by the court. Second, petition is filed challenging the investigation. The grounds taken there are the identical grounds that are being argued in the appeal. There is literally several paragraphs copy and pasted between that and the appeal hearing. Para 5. It is further humbly submitted that the appellant has sought to raise.
You are repeating Singapore statements.
Yes. Yeah, what?
I'm sorry, Lordship, I missed that.
Yeah, what?
Yes.
Sorry, Lordship, I missed what Lordship was saying. I had a break in my connectivity.
I said that you are speaking the Singapore language.
Singapore language. Ah. Lordship, like Lordship said earlier, that one particular person has gone bankrupt so many times. That was so witty. On this, Lordship, para 5. It is further humbly submitted that the appellant has sought to raise fresh and new facts in the present appeal, which were neither pleaded nor argued before the learned single judge. In light of the same, it is most humbly submitted that the appellant does not deserve any indulgence under the equitable jurisdiction of the court on this ground alone, and the present appeal deserves to be dismissed. Lordship may now come to pay para 31, which will be 738 now, I believe. Because, Lordship, arguments were raised on the printing press and the answer sheets. So I must point out, Lordship, what is the stand of the state? Para 31, Lordship. May I read?
Yes.
It is pertinent to point out that in the pleadings, additional affidavits filed by the writ petitioners, writ appellants in the present batch of appeals, and during the arguments, a stand is sought to be taken that the answer sheets khata booklet were not printed in the Assam government press. The same is vehemently denied being incorrect and misleading. It is submitted that the answer sheets khata booklet of the CCE exam 13 and 14 were printed at the Assam government press. The principal controller of examination, APSC, had requested the director of printing and stationeries, Assam, for printing of the answer sheets khata booklet by day letters dated 5/5/14 and 10/4/15 for the CCE main 13 and the CCE main 14, respectively. Lordship may mark that annexure R2 is at page 831. That's all. I'm not showing it, Lordship, merely just informing Lordship where it is. Now, Lordship may come to para. The para-wise reply starts at page 768, Lordship, which is para 86. It starts there, but I will read para 87, Lordship.
Mr. Kohli, in this, there was a specific submission,
Lordship,
by
Mr. Chaudhary, I remember.
And one more, I won't remember. It was very specific that the RTI reply.
Mr. Parparam.
Huh?
Arup Parparam.
And as per the RTI reply, this answer scripts are printed, not in the press.
Yes, Lordship, which is what we are refuting. Shall we go to the annexure, Lordship?
That we have seen, you have sent a letter, but the
yes, Lordship.
But this
so, Lordship, two things, if I may just
printing press.
Yes, Lordship.
The government printing press has given a certificate, it is not printed there.
Lordship, let me answer that straight. This is the state on affidavit. It will, and this is a state before, no less than Lordship, the Constitutional Court, and before Lordships, the division bench, saying so on this affidavit. There is some meaning to our document, Lordship. A worded RTI document is not going to, Lordship, mitigate against the stand on affidavit of the state, Lordship. I am saying that, Lordship, very clearly.
No, it can be otherwise. A document, if it is contrary to the affidavit made,
yes,
the affidavit will become a false affidavit.
If Lordship desires me to revert on this specific fact again, bringing and only to the effect of this particular fact, I can also bring an affidavit to that effect, Lordship.
No, not at this stage.
Not at this stage.
No, only to, I say, no, Lordship. At this stage, it is not a fresh argument. I am merely rebutting provided lordships want me to do that.
No, no.
That's all. I'm saying, lordship, I'm putting forward my best foot. That's all. To assist lordship because I'm duty bound to do so. So lordship, I wish to request lordship to come to para 87. It is the second paragraph of the para-wise reply. It starts at the para-wise reply starts at 768, but I'm referring to 769. And lordship, only I was just saying, since Mr. Das in this matter has filed several affidavits, I could do so, but I will do it only if lordship wants me to do so. That's all.
Because once we are
Because
telling
I-
it, you
No, no,
can't
no,
permit
not at this.
draft readings.
Yes, lordship. 87. The contents of para 9 to 39 of the writ appeal are denied, being incorrect, misconceived, and misleading. It is submitted that the investigating officer of the Dibrugarh police case 936 of 2016, it should be lordship, sees the answer script of the appellant bearing book number so-and-so, General English Code number so-and-so on 4/11/16, Vide MR number 334 of 2016 at page 349 of the appeal, on the very first day of the seizure from the house of Rakesh Paul. Please, lordship may mark this, why I'm reading. An argument is made on faulty investigation. Let us see the glorious track record found on the very first day of investigation of this gentleman, lordship. In the said answer script of the appellant, seized on 4/11/2016, the marks obtained is 141. Thereafter, the tabulation sheet, the 9-page lordship of the APSC was seized by the IO, Vide MR number 34916 at page so-and-so of the appeal on 21/11/2016, wherein it was found that the marks of the appellant, please mark, in the tabulation sheet is enhanced to 191. It is submitted that there is an illegal enhancement of 50 marks against the appellant in the final tabulation sheet. Furthermore, a loose rough sheet of 9 pages was seized by the IO Vide MR number so-and-so on 12/11/2016 from the house of Rakesh Paul. In the said loose sheets, against the name of the appellant, the original 141 total marks secured in general English appears with the addition of plus 50, encircling the total as 191. It is this 191 which is reflected in the tabulation sheet seized by the MR number so-and-so by the IO on 21/6/2016. On further scrutiny of the said loose sheets, it was found, qua the appellant, that in the sociology paper 2 with code number 198 as against the original total mark, the same was altered and enhanced to 90. Furthermore, same is the case with regard to the economics paper 1 with code number 32 of the appellant, wherein his original mark was 61, which was enhanced to 111. It is pertinent to highlight that such enhancement of marks of the appellant in both of the papers, as found in the loose sheets, are by the process of overwriting, addition over the original marks. It is submitted that the forensic report of 2019 of the 9 loose answer sheets received by the IO on 5/4/21 established that there has been alterations as submitted herein above. It is significant to note that the answer sheets of these 2 papers could not be verified as the same along with the others are missing, as has been informed by the APSC. But there is clear evidence, lordship. Then, lordship, it is further submitted that the reliance placed by the appellant on the RTI reply dated 27/15 of at so-and-so page is utterly misplaced and misleading. In fact, the RTI reply strengthens the case of the respondent state, as the mark stated to be awarded to the appellant in the RTI reply is consistent with the matching with the tabulation sheet seized by the MR number so-and-so read with the forensic report of the 9 loose answer sheets, which establishes that there have been alterations as submitted herein above. It is also pertinent to note that the RTI reply of 2015, which is prior, please mark lordship, prior to the seizures made on 21/11/2016 and MR number so-and-so on 4/11/2016. It is submitted that the reliance placed by the appellant on the interim orders passed by the learned single judge is misplaced, misconceived, and misleading, as the said orders stand merged with the final impugned judgment dated 18/3/20, by which all the discharge orders passed by the state have been upheld by the learned single judge. It is further submitted that the affidavit in opposition and in the additional affidavits filed by the state in the present batch of the matters was pursuant to the liberty granted by the learned single judge by the order dated 18/6/2019. The writ petition of the appellant was also listed on the said date when such liberty was granted. Admittedly, no appeal, review, etc. was filed by any of the parties in the present batch of matters against the grant of such liberty vide order dated 18/6/19. Therefore, any submission of the appellants to the extent that the same was filed without leave and permission of this honorable court is misleading and deserves to be rejected. Furthermore, admittedly, charges have been framed against the appellants by the order dated 19/4/22 by the learned trial court for the illegalities committed for obtaining the job. Hence, there is a prima facie case against the appellant, which has led to the framing of charges. Any submission to the contrary is denied, made here and above, are respectfully reiterated. Now, Lordship may just mark, I'm not reading it. Para 88 is where, Lordship, we have dealt with all the explanations required to what he has said. Lordship, it goes into several pages. I'm only for paucity of time, not taking Lordship through it, but this is just to place on record that we have dealt with all these contentions.
Okay.
Now, Lordship, if Lordship would permit me to make my Lordship closing comments. Lordship, the 4-5 things that I have argued over the last few days that Lordship has been so indulgent in giving me the opportunity. First is, Lordship, that all the appellants are probationers. Oh, Lordship, before I close, I'm correctly reminded by my colleague, I must refer to the sealed cover so that it does not go unrefuted, Lordship. Lordship, on the sealed cover, I have 3 sentences to make, Lordship. We submitted, Lordship, all the files in a sealed cover to the learned single judge because of the stage of the criminal trial at that point of time. It is to be noted that my dear friend and senior colleague, Lordship, Mr. D.K. Mishra, sir, has himself filed copies of charge sheets and placed reliance on them subsequently, Lordship. So the argument of sealed cover will not hold water, first. Second, the Honorable Supreme Court has also, Lordship, in cases like the Bhima Koregaon, in the Rafael matter, accepted sealed cover. It's not as if sealed cover has been rejected in all cases. Should this court, Lordship, wish to examine all the files, we are happy to bring the original records before Lordship. That exercise having been done, if Lordship so desires, the state will assist Lordships and provide all the files. Because the only issue, Lordship, with regard to the sealed cover or the argument was for the learned single judge to be satisfied whether the final decision of discharge was the material of the investigation was a foundation or a motive, and the learned single judge has already held it to be the motive and not the foundation, Lordship. Now, Lordship, if I may close my arguments, Lordship, what is my case, Lordship? In addition to the points I've already argued, just a short submission. All the appellants are probationers, Lordship. There is no confirmation or deemed confirmation in any of the appellant's case. So therefore, Lordship, there cannot be any concept of vested right of confirmation, because as per the applicable rules, confirmation is possible only upon the satisfaction of the appointing authority, which means a positive act, which needs to also be communicated. That was my first line, Lordship, of arguments. Second, Lordship, I had pointed out, the letters of appointment were temporary I showed specifically, Lordship, Taxation and Transport Department. That was at page 391 of the Kunal Das appeal, Lordship. And what it says is basically, if you are a probationer and if the statute requires a specific act of confirmation, then deemed confirmation would not be applicable. Durgabai Deshmukh, all the judgments. Next, Lordship, I argued that there is an incorrect reliance on the OM of 30th of August 2004. The transfer order does not and cannot be treated as a confirmation in service that could have been done only under the rules as per satisfaction of the appointing authority. This, Lordship, OM was only with regard to the posting in a battalion after completing 2 years of probation, where it was reduced from 1 year to 4 months. This order, Lordship, this OM cannot mitigate or dispense with the applicability of Rule 17 of the rules. We know, Lordship, an OM cannot override a statutory rule, which is a subordinate legislation. Then, Lordship, on 311.
Please come back to the last one. Please repeat it again.
Yes, Lordship. I said the last point being that the OM of 38/2004, which is only with regard to posting in a battalion and reducing the period from 1 year to 4 months, cannot mitigate against or dispense with the applicability of Rule 70 of the rules. Mitigate against or dispense with the applicability of Rule 17 of the rules. Because law, it is settled law, Lordship, and OM cannot override a statutory rule. Because the statutory rule enjoys the position of a subordinate legislation.
That's all.
Now, Lordship, this is a without prejudice argument, Lordship, obviously, because my main argument is that OM is only with regard to posting and does not in any way amount to confirmation, which has to be done in the manner prescribed under the rules, which is 17, which is a positive act of confirmation. So therefore, Lordship, my argument always has been that they are probationers discharged while they were probationers. There is no confirmation. This OM argument is my without prejudice argument. 3, Lordship, next, Lordship, Article 314. 311, Lordship. The applicability of Article 311 is not disputed, Lordship, because that is the law. We know that. However, in the instant case, it is not applicable. That is our case. Because it is a simpliciter discharge order which is not punitive. I have several times argued, Lordship, the police investigation or report amounts to the objective material that was relied upon for the subjective satisfaction of the authority, and finally the decision that was taken to discharge the probationers, meaning it was the motive, not the foundation. The intent to punish is not there. It is about the suitability of the probationer continuing in service. So they were all probationers. That's my argument, Lordship. I have already, Lordship, argued on Ratnesh and distinguished it, and para 19, Lordship, is what I relied. I'm not repeating that, Lordship, because I've done so in detail. Next, Lordship, the principles of natural justice and its alleged violation. Lordship, there is no straitjacket rule, and it is flexible, which is what I've argued. The point being that the single judge has gone through, the learned single judge having gone through the records, and he has excluded the applicability of the principles of natural justice. The settled law is, Lordship, I've already taken, Lordship, through the doctrine of empty formality about how it cannot be stretched to such an extent. All that I've already done so, Lordship. Sealed cover, Lordship, I have already argued, Lordship. The crux of my case, Lordship, is that these are appointments that are void ab initio because of the entry being tainted. The exercise of segregating the tainted from the untainted or the non-tainted, that detailed exercise was done by the state, and the police investigation is that detailed exercise. Having segregated the tainted from the non-tainted, the state has followed the settled law of basically discharging these probationers and not cancelling the entire examination. I've done with all the judgments and also distinguished how their reliance would not be correct in terms of the Amarveer 1, Amarveer 2, Indrapreet Kehlon, and Supreme Court's Joginder Pal Singh. Next, Lordship, I've argued the argument of social injury in them continuing in office. I have argued the obligation of the state to protect the public office and the public trust or the trust of the public in the occupiers of the public office. And bringing back such persons who have been discharged on the bona fide action of the state to protect the public trust and the public office would amount to social injury, Lordship. So I've spoken of the obligation of the state to do so. Next, Lordship, there is no infraction of any right that they can claim, much less an infraction of or an allegation of infringement of a fundamental right. And lastly, Lordship, they have to show what is the error or the perversity in the judgment of the learned single judge. Because at the appellate stage, there cannot be reappreciation of the same evidence or the same material that was considered by the learned single judge unless a perversity or an error is shown. Because it's the scope of it has been defined, Lordship, by the Honorable Supreme Court. And second, Lordship, there cannot be introduction of a new argument or a new document. That's very critical, Lordship. Which means fresh material for consideration at the appellate stage. Then, Lordship, I have also shown, Lordship, the law on the mandamus. That's the crux of my arguments, Lordship. Now, just to close it finally, is, Lordship, I wish to, my colleague, Mr. Dipankar Nath, is carrying copies, that the investigation was challenged by the second batch, Lordship. They are not the appellants here. And that investigation challenge had reached the Honorable Supreme Court. I'm just showing that one order, Lordship, of the Supreme Court. Just for the record, that the investigation and the argument with respect to any challenge of the investigation per se has been rejected by this Honorable Court and upheld by the Supreme Court, which means the investigation is where it is. Not, and Lordship was saying something?
That's not correct.
My learned friend Arnab and I were there. He will, I'm sure, point it out. I'm saying it's for the second batch.
In the context of charge sheet number 14 that was submitted, my lord, on 12th September 2024.
Right, I'm coming to that, Arnab. Let me finish it.
The contention raised before this court in a petition under 482 was that the police did not conduct any further investigation. Rather, on the same material, it reassessed and reappraised the same material and filed the charge sheet, which the High Court said, no, there was some fresh material which came went to the Supreme Court in limine dismissed. It cannot be said that I have challenged, my lords, the nature of the investigation or gone into the merits of the offences. No, my lords. It's only on the issue, my lords, whether any further investigation was conducted.
Right. So I was about to do, I would have saved my learned friend much effort, because my next sentence was that it was in the context of what was the investigation and the charge sheet filed after the SIT was formed. And Lordship, that SIT argument has been professed here. Even if it's not professed by my learned friend, it has been professed in great detail by the counsels of the appellants. And Lordship, that contention of the further investigation, I've shown the point of law that it does not in any way invalidate the preceding charge sheets. So therefore, Lordship, I am still careful to say that the aspect of the investigation which extended into the SIT, which had resulted in the following charge sheets, including charge sheet 40, was challenged or placed before consideration by the appellants in the other batch, which is not this batch, came before this court, and this order, Lordship, of 22nd of May 2025 has declined to interfere with the order of the Honorable High Court, Lordship, and given the liberty to the petitioners to raise all contentions before the trial court. So therefore, Lordship, to close that argument, I am merely saying anything qua the criminal investigation has to be raised before the learned trial court or in the petitions that are challenging the investigation. They cannot be brought here to somehow argue that the discharge of a petition of an appellant or a person who is a probationer under the rules by the state has to be turned away on the basis of the criminal trial. That's what I'm saying. I'm so grateful, Lordship. I have finished my submissions. I'm deeply obliged to Lordship and leadership for the time that was given to me, Lordship. And true to my word, Lordship, I seem to have left some time for my learned friends on the other side of the bar to subject to Lordship and Ladyship sitting further, taking their arguments today.
Yes, Mr. Mitra.
If I may from also, Mr. Kane for this advocate also will be appearing to VC tomorrow, Lordship, at 2 o'clock, Lordship. I'm supposed to start work.
Okay. Mr. Vishnu, the argument is there.
Yes. Well, the submissions that have been made by my esteemed learned friend, Mr. Kohli, I'll reply one by one, which is relevant to me. The first is, he placed the transfer order which I placed earlier, which is dated 15/9/2017 at page 81. This was the order. It's wrong to say, with all respect, my lord, that it is a mere transfer order. No, it's not a transfer order. It's an order which is passed transferring the probationer to a post on completion of the period of probation. Let me just place, my lord, paragraph 85. Page 85, I'm sorry. Page 85.
Of which brief?
Of Sabira Imran. WA 196 of 2020.
Today's item number?
Today's item number 5. 26.
20?
26.
26.
My lord, did you lordship get page 85? I'm reading the last portion, last paragraph.
Yes.
The above posting of APS junior grade batch have completed probationary period of 2 years. This is the first part. So they have completed the probationary period of 2 years. Now, what is the prescribed probationary period? That your lordship will take this compilation of item number 26. And take your lordships through the rules, rule 15. But on this compilation,
Yes, you may refer it because we have said it, we have
Alright.
it's
Alright.
being analyzed.
So 15 minutes. All persons recruited to this service shall, except person recruited under 5.2, we are not concerned, be on probation for period of 2 years from the date of appointment to the service. Now, what is the date? What is the duration of probation? 2 years. So probation period mentioned is 2 years. And she has completed 2 years. Now, your lordship, my one submission, your lordship will record it. There is difference if I say that the probationer has completed probationary period of 2 years, and we say that the probationer has completed 2 years of probation, as if the probation is for more than 2 years. And this is how things have been twisted. I'm sorry to say that. Because the probationary period is 2 years. And he has completed 2 years of probationary period. It's as simple as that. Then, your lordship, the second point I will come later. Now, your lordship will at page 85 only, if your lordship will see and notice, in the interest, third is, my lord, the serial number third is the appellant. At page 85 only from top, the third one.
Yes.
In the interest of public service, Srimati Sabira Imran APS Direct Recruit 2015 Assistant Commandant so-and-so is posted as Assistant Commandant 12 AP Battalion Jamurgudi. Your lordship will see the expression probationary is conspicuous by its absence. It is not mentioned that she is a probationer, still a probationer after completion of 2 years.
Yes.
Now, before completion of 2 years, wherever there is an attachment order or the movement order, she has been described as DSP probationer, P. Your Lordship will come to page 74. Page 74 of the paper book. Your Lordship will find Sabira Imran's name is at page serial number 24. DSP-P is probationer. All the officers have been mentioned as probationer. Because, my lord, unless there is a posting after completion of the probationary period, there will be only movement order and attachment order. Now, your Lordship will come to page 76. 76. It's a WT message.
And in this page 74, even in page 74, even my
Yes.
name appears in two column.
Hamnam. Now, my lord, your Lordship will come to page 76. It's a WT message. Don't you got it?
Yes.
Government, it's a WT message. It's order dated 6/12/2016. She had not completed 2 years of her probation. Government passed the following posting orders of DSP-P probationer. So and so in pursuance of the provisions contained under 15(3) of the rules 1966. The following probationary deputy superintendent of police are hereby attached for a period of 9 months and 7 days for practical training in the district police as shown against their name. Now, my lord, we'll turn to the next page. Next page, my lord. Sabira Imran is at serial number 22, my lord. All are 2015 batch APS officers, all have completed their probationary period. Now, your Lordship has seen at page 85, there is no probation word is not there. Why it is not there? Because they have completed their probation. This is what the order says. And this order, transfer order, is after completion of the probation. Now, your Lordship will see yet another aspect. In transfer order, your Lordship has seen DSP probationer is not there. Now, at page 134, if your Lordship can come to suspension order 134. Whereas a report has been received from Superintendent of Police Dibrugarh by so-and-so that Sabira Imran, APS Assistant Commandant 12, so-and-so, has been arrested in connection with so-and-so, so-and-so, which is unbecoming of a police officer, and then she was placed under suspension till pending drawal of the departmental proceeding. Now, here also, your Lordship, kindly see, probation word is not there. Even in suspension order, the probation word is not there, my lord. But if your Lordship will see the impugn order, my lord. The impugn order. My lord, impugn order is at page 135, just next to 135. Now here, my lord, it is 27 July 2018. Your lordship will see probationer comes again. This is not omission or a typing mistake. This order is passed mentioning her probation so that they can argue that they are all probationer as they are arguing. Now, my lord, the second part of at page 85. Second part, I have only said about completion of the probation. Then second part, your lordship will see. Above posting of APS junior grade have completed their probationary period of 2 years and are exempted from mandatory posting in the battalion for a period of 4 months as per OM 38/2004 as their services are required. Now, this is at page 179. At 179, these are the exemption order. My lord, the exemption will apply only to officers who have completed their probationary period and to none others, not those who have not completed. I'll place it, my lord. This is OM dated 30th August 2004. In partial modification of this department, OM number so-and-so dated 25/9/2003, the period of compulsory posting in respect of newly recruited Assam Police Service junior grade officer in Armed Police Battalion. Your lordship will kindly mark it. After completion of prescribed probation period of 2 years, is reduced to 1 year 4 months. So this exemption is available to those who have completed their probation. So, my lord, therefore, the submissions made on behalf of the state that they are all probationer is contrary to the record. The next point is, my lord, what is the case of the government? Why they have discharged us? Is it a discharge simpliciter or is by way of punishment? That if I take your lordships through some of the statements that have been made in affidavit in opposition, it will be clear. My lord, at the outset, I am submitting total confusion prevails in the pleadings of the state. They themselves don't know why they have discharged them. Was there an inquiry to find out their suitability to this to the post? Obviously, no. No record has been placed. Now, first they say, my lord, that the appellants have been discharged because of loss of public trust. Loss of public trust is a creation of the state and its instrumentality by reporting to the media, if at all there is. This they have stated, my lord, in paragraph 15. I'll not waste your lordship's time. Your lordship may see this is stated in paragraph 15 of the AO at page 150. AO of the state starts at page 144. Paragraph 15 is at page 150. And all AOs are similar, my lord. Even Pallavi, these cases are there, whom I am representing. I'll give the numbers there. $150, if your lordship will see. I'll just quickly take your lordships through. All writ petitioners in the present batch of writ petitioners before this honorable court are those who are identified beneficiary who have been found to have participated in this colossal fraud for public employment. This colossal fraud has not only resulted in hundreds or maybe thousands eligible meritorious candidates in the state of Assam losing an opportunity to be deservingly appointed against the various posts, but it also made huge dent in the faith and confidence of the resident society, state, in the functioning of the public authorities, occupants of the public offices, thereby seriously prejudiced public interest, requiring appropriate imperative corrective measures, including discharge from service. Now, they have jumped to the conclusion from where you got this. So the first they say the loss of public trust. Then they say the entry of the appellant in service is not clean.
Yes.
No, my lord, if your lordship will come to page 162. Paragraph 48.
Yes.
Paragraph 48 at 162. While petitioner was serving on probation, the respondent write notification dated 27/7/2018 in exercise of power conferred under 16B of Assam Police Service Rule 66 discharged the petitioner from service with immediate effect. This is wholly without prejudice to the submission that all the cases of present based of writ petitioners are cases requiring securing appointment to public office by fraud, and the petitioners are not entitled to remain in these offices. And all contentions relating to probation protection of Article 311 and other principles of service law applicable only in those cases where there is no question mark on the process of selection of and securing appointments are not at all available to any of the petitioner. All the writ petitioner deserves to be dismissed. So they are trying to distinguish that our entry is by fraud, therefore question of application of 311 doesn't arise in paragraph 48. Now, having said that, my lord, they have made another statement at 65, my lord. 65 and 75 at page 168. 168 saying that it is not reasonably practicable to hold an inquiry. At page 168. Your Lordship found it.
Yes, yes.
One-
Para 65.
All right. Yes, without prejudice. They have given 10 reasons, all hypothetical, and say without prejudice, without prejudice, without prejudice. So say, what is your case? Why did you do this? Without prejudice to above, it is most respectfully submitted that in terms of the proviso to Article 311, whenever it is observed that it is not reasonably practicable to hold any such inquiry and envisaged under Article 311(2), it will not be necessary to give such person any opportunity of making representation, and the said provision shall not apply. In the present case, having regard to the materials which have become available during the detailed and thorough investigation carried out by Assam Police, where beneficiary of colossal fraud in the recruitment process have been found to be unfit to service in public offices, it has been found not to be reasonably practicable to hold under the second proviso B to Article 311. Now, my lord, Article 311(2), the proviso, is a mandate of the Supreme Court in Tulsi Ram Patel, which my learned friend Mr. Kohli referred, and I'll place that. First, if your lordship will kindly take 311 from the Constitution, I'll place that provision.
Yes.
300, Article 311, I'll come to 2, my lord. No such person as the aforesaid shall be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and given reasonable opportunity of being heard in respect of those charges. These are the law. Then, my lord, the proviso. Provided, second proviso I'm reading, my lord, provided further that this clause shall not apply where a person is dismissed or removed or reduced in rank on the ground of conduct which has led to his conviction on a criminal case. This is not the case. Where authority empowered to dismiss or remove a person to reduce him in rank is satisfied that for some reasons, your lordship will kindly mark, to be recorded by that authority in writing, it is not reasonably practicable to hold such inquiry. This is my case. Where is the reason, my lord, I have placed before your lordship? I have not given any reason why it is not reasonably practicable to hold inquiry. My lord, Tulsi Ram Patel, if your lordship remembers,
Yes.
now Tulsi Ram Patel, my lord, is a case which consisted of 3 cases. One was railway employees who has gone on a strike. Another was the CISF. Another was CISF. They were stationed in Bokaro and they wanted that they should be permitted to form an association. So these were the cases where doctrine of pleasure also came, my lord, 310, and it was held in paragraph 62 that doctrine of pleasure is abridged by Article 311. of the Constitution because of its requirement. Now, but this is basically a case under 311(2). And giving of regions under 311(2) proviso is constitutional requirement. I'll place paragraph 133 of Tulsi Ram Patel. My learned friend will hand over, my lord. Lordship got it?
Yes.
I'm reading 133. The second condition necessary for the valid application of clause B of the second proviso is that the disciplinary authority should record in writing its reason for its satisfaction that it has not reasonably practicable to hold inquiry as contemplated under Article 311(2). This constitutional this is a constitutional obligation. And if such reasons is not recorded in writing, the order dispensing with the inquiry and order of penalty following thereupon would both be void and unconstitutional. There is no reason.
Yes.
Now, my lord, I come on deemed confirmation.
The reason must be there.
My lord, I will explain the principle behind deemed confirmation. My lord, deemed confirmation is a concept which will apply where maximum period of probation is mentioned. And how it applies in our case, that I will also place. So I'm saying, Miller, the concept of deemed confirmation will apply where a maximum period of probation is mentioned. And if a probationer is allowed to continue beyond that maximum period, then the question arises, in what capacity did he continue? He cannot continue on probation, so he'll be deemed to have been confirmed. This is the concept. Now, this concept, my lord, was laid down by in Dharam Singh's case. In Dharam Singh's case, my lord. Your lordship will take this compilation, which we have filed in this. The citation is 1968 Supreme Court 1210, paragraph 5.
1968.
SC Supreme Court, 1968 Supreme Court 1210, paragraph 5. Page 67 of my compilation. Your Lordship will come to page 67 of the compilation.
Just a moment.
It's a good thing.
Compilation.
Relevant paragraph 5 is at page 71 of this compilation. Yes.
Second copy. Second copy.
Read appeal 196 of 2020.
196 is item number?
Item number 26, my lord.
26.
Item number 26.
Yes, please continue.
I'm placing at page 71, paragraph 5, just to show the principle. In the present case, Rule 6.3 forbids extension of the period of probation beyond 3 years. Where, as in the present case, the service rules fix certain period of time beyond which the probationary period cannot be extended. And an employee appointed or promoted to a post on probation is allowed to continue in that post after completion of the maximum period of probation without any express order of confirmation. He cannot be deemed to continue in that post as probationer by implication. The reason is that such implication is negated by the service rules forbidding extension of the probationary period beyond the maximum period. By it, in such case, it is permissible to draw an inference that employee allowed to continue in the post on completion of the maximum period of probation has been confirmed in the post by implication. So this is the principle on which the deemed confirmation or confirmation by implication is called out. That maximum period is mentioned. You have allowed the probationer to continue beyond that period. In what capacity will he continue? He cannot continue as probationer because his probation period is maximum probation period he has already reached. So he cannot continue. So he can continue only as a confirmed employee. This is the concept of deemed by lord confirmation or confirmation by implementation. My lord, how this applies to our case? Yes. My lord, in the case at hand, Rule 15, your lordship has seen. Rule 15. There is no stipulation of any maximum period, then how this will apply? The confirmation by implication. The Lordship will see
And 9 by the code. Go ahead.
rule 15.
Yes.
I'll read rule 15 again, Melon. The second part of it, which contains the provision for extension. All the persons
Yes.
recruited to the service shall accept the person recruited under 5(2) be on probation for a period of 2 years from the date of appointment to the service. The probation period may for good and sufficient reason be extended by the governor in individual cases by such period as deemed necessary. So there is no maximum period prescribed for probation. Now, how am I bringing it? Well, I am bringing it within the concept of confirmation by implication on the basis of the order dated 15/9/2017. On the basis of order dated 15/9/17, which Your Lordship will get at page 81. I have referred it. Your Lordship recall.
Page 85.
Lordship
Page
need not
85.
open it.
Page 85.
Yes. Now, my lord, on 15/9/2017, there is an order that my probation is completed. The period of my probation is completed. After that, I have continued. And in what capacity, I'm asking the question to myself, in what capacity I could have continued after completion of the probation period. Once the probation period is completed, it cannot be said that, no, you are still on probation. These are, the Lordship will see this, that is the reason in the discharge order they have mentioned, they have brought back the expression probation. It was not there in suspension order. It is not there in 15/9/2017. And they brought it, my lord, again, the discharge order. My lord, on the face of express order that I have completed the probation period, there is nothing more can be done. And I have been allowed to continue. In what capacity I will continue? This is a question that I ask myself. And therefore, my submission will be, my lord, that the confirmation is by implication. Well, this is a unique case. I have not got a single case where they have said that probation is completed and thereafter, my lord, they say that you are still on probation. And that too, by bringing an extension order of 20th January 2018, almost around 6 months, 4 months after they have passed this order of 15/7. After 6 months, they brought in, my lord, the extension order saying that my probationary period is extended. And that is how, my lord, we are saying, what is the authenticity of this order? We have written to the officers to whom you have endorsed the copy, your own additional Director General, all your officers. There is no reason to lie, my lord. They said we have not received, our officers have never received such kind of communication. And moreover, my lord, this is admittedly, I can say now, it has not been published in the Gazette. Gazette gives authenticity of any order, my lord, which is passed by the government, by the governor. It is not there. They have not been able to produce. Rather, they accepted before the earlier division bench, my lord, presided over by the then Chief Justice Sandeep Mehta, that they don't have. What is the authenticity of this order? After 6 months, in what capacity you have continued me? Now, my lord, I come to another point because I have referred, my lord, in my opening argument, they referred to Chandra Prakash Sahi and saying that the express order of confirmation is required.
Yes.
My lord, it's my humble submission. It will depend on the rules. Number one, whether a confirmation order, express confirmation order is required or not required, or it could be by implication. If your lordship will come to Rule 17, Rule 17 of the rules, it's in the same compilation, my lord, if your lordship have that at page 7. 17.
Come to the law.
17, my lord, I'll place with your lordship. Your lordship has got it.
This is the second book.
Yes, yes. No, that is the first one, this one, page 7. The rules start from page 1.
Okay.
APS rule, page 1. Relevant 17, your lordship will get at page 7. Page 7.
Yes.
A person appointed to, well, there are 3 requirements contained in A, B, C. The first requirement is, and this is most important, and rather I'll say the only requirement which cannot be dispensed with, that he has completed his probation to the satisfaction of the governor. A. Now, the moment your lordship will look at 15/9/2017 order and says that I have completed the probationary period of 2 years, that is, probation is always completed. If there is an order, it has to be on satisfaction of the governor. It cannot be said that we are not satisfied, but yet you have completed your probationary period. So A is complied in this case. So far as B and C are concerned, there is a power to relax. B is he has passed departmental examination and success only undergone the course of training in the prescribed for him. The third is a general, my lord, if he is otherwise fit for confirmation by the governor. Now, your lordship will see the exception. The 3 requirements, see the provided that where a member of the service is not given an opportunity for undergoing the prescribed survey and settlement training during the period of his probation, his confirmation shall not be held up. His confirmation shall not be held up for reason only of not having undergone such training, but such person shall, when called upon by the governor, an opportunity given, successfully undergone such training. So our confirmation cannot be withheld. The second proviso is, provided further that the governor may, for good and sufficient reason, temporarily exempt a member of the service from passing any or more of the prescribed departmental examination and confirmation in service. Therefore, there is no requirement of express order of confirmation in these rules.
We'll have to continue some other day because we'll have to rise. There's a single bench also.
Right. So tomorrow, my lord, I'll continue.
Yes.
I'll not take enough time. Much less.
Lordship is keeping it tomorrow also in the morning, Lordship?
Tomorrow we don't have a list right now.
Anyway, Lordship, I'll
Earliest possible, we'll try to take it up.
Then, Lordship, as always, Mr. Nath and Mr. Roy will let me know. I'll join in immediately, Lordship. I'll be prepared for morning or whatever time. Today, there's been some very bad news, Lordship, with that plane crash.
I'm not aware. Where?
Well, Lordship, I just had got distracted for a few minutes. The Ahmedabad-London Air India flight crashed on takeoff. And Mr. Rupani also, former Chief Minister, among some 240 passengers, are believed to have fully perished because it crashed into a residential area. So it's a terrible crash. After several years, we've had that kind of a crash. And the video is also available, broadly showing the plane just kind of taking off on landing or coming back and then falling into an area. So it's a very bad news today in aviation.
Air India flight.
Air
India flight.
Now, it just if it helps anyone, I traveled on Air India yesterday. My family is traveling on Air India tonight. And I have friends calling me who are traveling on Air India. Kya karna chahiye? How panic comes,
only you are
Lordship.
in London?
Yes,
Are you in London?
I happen to be perhaps.
That's why your face is going.
Lordship, that is being very unfair to my country of origin and the country of my pleasure and delight and my work. Grateful, Lordship. Thank you, sir.
Same order. Okay, I'm sorry, I forgot to dictate the order. First, you'll see the names of the council present, senior council present, the appellant. Next para, the submissions of Mr. N. Kohli, learned senior counsel, assisted by Mr. H.K. Hazarika and so and so, is concluded. Next para. The submissions in reply by Mr. D.K. Mishra, learned senior counsel, assisted by Mr. B. Prasad, counsel, in criminal appeal, rate appeal 98 of 2020 and rate appeal 196 of 2020 remains inconclusive. This is a parted matter on tomorrow 13. This, whoever is present, just give the names to the.
Great.
My lord. My lord, I would like to withdraw this matter.
This bill application?
Yes.
Your name?
My name is Zakir Hussain, Zaid Hussain.
Okay, Mr. Zaid Hussain. Upon instructions, Mr. Zaid Hussain, learned counsel for the petitioner, seeks to withdraw this bail application. So Mr. K. Boshal under APP is present. Matter stands dismissed on withdrawal.
Item 2, item 2,
There is no representation from the petitioner. Mr. K. Boshal under APP is present. Matter stands adjourned today. List. List after a week.
item 3,
Bail application under section 483 of BNS even. And we have Orup Das. He's been languishing almost 1 year, pertaining to session case number 226 of 2024. In the meantime, co-accused has been released on bail by the Lanet Trial Court on 31/5/2025. Lordship. Altogether, 33 witnesses have been listed. Out of 33, only 6 witnesses has been examined so far. And we have submitted an additional affidavit regarding grounds of arrest. No grounds of arrest has been mentioned in arrest memo as well as section 50 A CRPC. That has been annexed. Bail order. I'm submitting the bail order passed by the Lanet Trial Court, Guwahati, regarding co-accusation. What the accused arrested on same date and forwarded on the same date. As per the order of Lanet Trial Court, minor has been examined. There is no chance of influencing the witnesses. Out of 32 witnesses, only 7 witnesses has been examined so far. On coming 26th, your lordship, 1 year will expire regarding detention period.
Mr. Boshal, then there's something very wrong here. This order was passed on the ground that the accused is a minor. In that case, if it's a minor, why a sessions trial is going on?
Then it should not be in the.
Look at this order.
It may be a typographical error.
No, we don't know. It's when it's a court's order, we can't presume it's a that's
We have downloaded the same from the website. My lord.
no, whatever we but the order says that the accused is a minor. If it's a minor, then our sessions trial can go on.
Undoubtedly, accused are major, your lordship. It is a typographical error. And that accused not represented by us.
Then please find out. The records are here, Mr. Bishop, please go through it.
My,
Just check up if if that accused who's granted bail is a minor, because then we'll have to register a suo motu revision.
my,
It was on incorrect considerations that bail were granted. We'll take it up after some time.
Item 4, review petition 63/24 for orders.
My lord, by this review application, my lord, the petitioner is paying for review of the judgment and order dated 21/04/2023. Here, my lord, the petition was dismissed with cost of rupees 10,000, my lord. And hereby paying for review of the cost, my lord, and my lord, the aspect of seniority, my lord. Because some materials could not be brought before your lordship at the time of hearing, my lord. Petitioner has already deposited the cost, my lord, before the college, my lord, college authority, Babuji College Authority, my lord.
What is the ground of review?
My lord,
What is the grounds of review? What are the grounds of review?
my lord, we have stated in paragraph page 17, my lord. My lord, the petitioner was, my lord, initially appointed in a non-sanction post and subsequently, my lord, against lien vacancy on, my lord, 8/1/1998. And on lien vacancy, my lord, after following all procedure as per law, my lord, he was appointed, my lord. And in the advertisement, my lord, it was clearly mentioned, my lord, that that post was likely to be vacant, permanently vacant, my lord. And since the incumbent, my lord, did not join in the post, later on, my lord, he was permanently, post was regularized against that post, my lord. And accordingly, my lord, he was claiming his seniority from the date of, my lord, joining in the sanction post on lien vacancy. That is, my lord, date of 08/01/1998, my lord. But, my lord, in the writ petition, he did not bring, my lord, any document to show that he was appointed against the lien vacancy after following due procedure of law, my lord.
Where is the advertisement?
My lord, page 163, my lord. That is type of P. Original is 164, my lord.
Where is the prayer in your petition?
My lord, page 57, my lord.
57.
57. my lord. We are not on review of the prayer, my lord, 1, 2, 3, my lord.
Mr. Das, for this reliefs, repetition would not be maintainable.
That is why, my lord, we are not praying for reconsideration of those prayer, my lord.
Then there is no review. Review will not lie.
My lord, only for the consideration of seniority, because my lord, this aspect was not.
That can't be done. That has already been addressed in the order. And you see the prayer you have made. You are a lecturer. And your prayer is
My lord.
to set up a mechanism to redress the grievances of the faculty members of the college as well as students against mental harassment. Second prayer is appropriate steps by respondent number 4 to prevent respondent number 4 from indulging in continuing practice of mental harassment.
My lord.
3, issue writ in the nature of mandamus directing mental fitness check in appointment of teachers.
That should
So
not
that
be-
means we'll have to presume that the persons who are applying for the post of teachers or professors are mentally unsound. Only those people will apply.
That should not be prayer, my lord, in the repetition.
We are
I
not in
admit,
time.
I admit. Only, my lord, this aspect can be considered if you have accepted.
What aspect?
My lord, seniority, my lord, over respondent number.
Seniority is not even a prayer here.
Seniority, my
To
lord.
maintain departmental seniority as per journey of service, that we have already rejected.
My lord, but your lordship has considered from the date of joining in the non-sanction post, my lord. And I am not on that, my lord. I am on the joining in my leave vacancy, my lord. Gain vacancy.
Leave vacancy is already, it's a temporary vacancy. It's not a permanent post. Is a leave vacancy permanent post?
But my lord, I am relying upon two judgments, my lord, if your lord.
Leave vacancy is a permanent post.
No, my lord, on temporary post also, your lordship may consider.
On temporary post, that's not a regular employment notification. You see, somebody would, many people may not like to join a service for 1 year. So they will not apply. You apply in a job for a temporary post.
But my lord, in the advertisement, there was a condition, my lord, that post is likely to be permanently vacant.
Where is that in the advertisement is not there?
Yes, my lord. Advertisement, it is there, my lord. Kindly see page 163, my lord, type copy.
163,
my lord. Annexure C, my lord. The applications with full biodata and attested copies of mark sheets and certificates from HSLC onwards are invited from the candidates having UGC norms for the post of a lecturer in English for a period of 1 year leave vacancy, but likely to continue permanently at UGC system.
so vacancy may be, you see, a vacancy may be may be there, but it's still a appointment against a leave vacancy.
My lord.
Leave vacancy cannot be treated as a permanent vacancy.
No, my lord, I am not on that. But my lord, I am relying upon the judgment of Honorable Supreme Court and Division Bench of this court also, my lord, in this aspect.
We'll hear it some other day because not today.
Yes, my lord.
We will not be able to hear the matter. Mr. Parvi, you are appearing
For 1 and 2.
for 1 and 2. Mr. UK Das, counsel for the petitioner, as well as Mr. D. Upamanir and counsel for respondent for 1 and 2. Standing for 1 and 2 are present. Due to positive time, the matter cannot be taken up for hearing today. List again on. Mr. Das, see a date and give a fixed date. This hearing will go to the after vacation.
My lord.
Give it after vacation. You'll get it after some time.
And Lordship, the petitioner may be directed to give me a fresh copy, Lordship, because my last page is 161 only, Lordship. And he has 164 or 65.
165. I will give a, give a. I'll find.
Highly obliged.
Item 5 for orders.
My lordship, youngest council can also they leave the court, my lordship.
Pardon me?
Leave the court, so kindly pass over the matter for the day.
Oh, last time also we adjourned the matter for that. This is, we are not expecting a senior council to wait for an adjournment till 4:30.
So actually the complainant, she has filed an affidavit where she says that she doesn't want to pursue. That is what she has said. So in view of that, the entire situation changes. So that of course would not debar the management from taking any steps as provided under law under the disciplinary procedure. So with that observation, the matter can be closed.
So we just say that this, can we pass an order to the effect that this review is closed?
Yes.
And the management will take a call in accordance with law?
Yes.
In view of the withdrawal of the complaint?
Yes.
Please respect, my lord, I filed an affidavit on behalf of the complainant. That online it is showing, but on record it has not come, my lord. I have checked the records.
Okay, what is that affidavit? Please give us a copy.
No, which can not the affidavit.
Okay.
What?
No.
No.
Where is your affidavit? Begum, where is your affidavit?
The respondent has filed no objection if it is the same has not been.
No, we understand, but where is your affidavit to say that?
They have not filed.
They have not filed. They have not.
You are not filed.
That's para 8, my lord. Page 278.
No, that the complainant's affidavit.
Yes.
Complaint, I have.
Start from page number 275.
275. Just hear the order and then suggest you need a change. Ms. R. Begum, Learned Counsel for the petitioner is, review petitioner is present. You just add the JMV. Ms. R. Begum, Learned Counsel for the petitioner, review petitioner. Mrs. M. Hazarika, Learned Senior Counsel, assisted by Mr. D. Khan, Learned Counsel, and
I'm for respondent number 4, ma'am.
and Mr. J. Royal and Senior Counsel, assisted by Mr. BP Sharma and Counsel for Respondent number 4 are present. Next one. Mr. N.K. Das, Learned Counsel for Respondent number 5. Has submitted that during the pendency of this review petition, where is that? No, where is that? The respondent number 5, who is the complainant against the petitioner, and had filed a complaint dated 28/7/2021 for sexual harassment at workplace. Has submitted a letter of request to the Internal Complaints Committee of Numaligarh Refinery Limited, requesting for letter dated 17/1/2025, with the Internal Complaints Committee of Numaligarh Refinery Limited, requesting for a conciliation, which is accompanied by the complainant's affidavit. Most of it is submitted that the same has been brought to the same has been filed along with a no objection affidavit filed by respondent number 5. First up, however, they said the original affidavit has not been brought on record. First up, upon instructions, the Learned Counsel for respondent number 5 has submitted that the respondent number 5 has no objection for the if the Internal Complaints Committee takes up her application of the request for conciliation. Correct?
Yes, my lord. Conciliation was not allowed. I filed under section 10, but it was not allowed. Then, my lord, I have file my affidavit before this honorable court
Acha.
because it was not allowed by law.
Okay,
that
so
was
can I
conditional, my lord.
add there? Yeah, it is also submitted that the prayer for conciliation was not allowed. And therefore, the same has been brought before this board by way of an affidavit.
My lord.
It was a conditional, my lord, withdrawn. It was conditional, my he is, she imposed some conditions. Last line, lordship may see, I would like to leave the incident with the given assurance that he would not file any case against the incident, and I also agree not to file any case. And
That has nothing to do with the
Correct.
IC.
Go between both.
That has nothing to do with the IC, Lord.
that is, the Sharma in any official capacity whatsoever, and preferably not in the same location. That he wants to say that he should not be posted in the same location.
Those things are beyond, but anyway, under section 10, they can't consider.
Yes. Last paragraph.
No, but then if they have already rejected, then we
Yes.
can't do anything.
I can't do anything.
We can't force, court order cannot force compliance.
No,
What do you
Lordship,
call
they
it?
can't.
Section
And
10.
this is not
we
within the
can't.
domain of the IC. Where to post him or where to
Yes.
not post him,
Yes.
that's not in the domain of the
That
IC.
part has gone, my lord.
Gone. Now
the
he,
situation is that
now she wants
I do
afresh.
not want to
I,
proceed.
she says, I don't want to pursue. That is what she has come here and said down on this affidavit. So
This is the
these
new
things needn't be gone into as such. Because IC's order rejecting her
No,
application
no,
has
we
been
can't go
challenged.
into it.
It
You are
has
right.
been
You are right.
challenged.
That is gone.
That's gone.
So we'll have to ultimately take up the review application, hear it, and then say whatever we want to
Mhm.
say under it. No, then don't write that. Then, just say, we got the presence, so are present, along with Mrs. MS Harika, Senior Counsel, Mr. J. Roy, and Mr. M. P. Das. So on the prayer made by Ms. Made by the Learned Counsel for the petitioner, the matter stands adjourned today, list on. Please take a date now, next time be there, or otherwise tell both the Senior Counsel you're taking an adjournment. I don't want Senior Counsel to wait
Let it be, my
till
lord,
4:30.
tomorrow, my lord.
Not tomorrow.
We are taking up those
Not tomorrow. Not
day-to-day
tomorrow.
hearing.
Monday, my lord.
Not possible.
No, Monday it's not
It goes
possible.
after
Lordship,
vacation.
let it be week after next.
That will be too far, my lord.
We can't help it.
It's too much. Let it be week after next something, week starting 16th
I'll
of June.
not be able to take up any hearing.
Absolutely, Lord.
I'm racing against time in that matter.
The lordship may pass that order, my lord.
Lordship may close the review.
Close the review, my lord.
That's what.
Yeah, the only
Instead
thing,
of going
only thing is that the management will do whatever.
No, as per law.
As per law.
Board cannot direct
Yes.
management to do anything.
Lordship can pass that on.
Yes, the Begum,
Yes.
Next week, my lordship, Tuesday,
next week he can't take up
after vacation,
can't.
any day.
after vacation then.
Ultimately, the result will be same, my lord, because
But since he's not there, they say he'll have to take a dismissal of review. He'll have to take a dismissal of review.
After vacation.
After vacation, any day.
You will fix it after vacation, Mr. Devin.
Okay.
But next time, don't take an adjournment.
Yes, no.
Even if you take, I'll remember it and will take up the hearing. Last time also you took an adjournment.
He is available in 3:30, my lordship.
No, whatever we but adjournment is something I will remember. Achha, just say that affidavit filed by respondent 5 is not on record. So the registry shall tag this as affidavit on record.
21 July.
Item 6.
This is the ground of the delay.
Delay, my lord, after the order was, your lordship's order was passed. Then, my lord, when pension papers were about to be processed, my lord, from the office of the accountant general, it turned out that the petitioner was not regularized because, my lord, all people who were getting benefits of Sanjita Roy's judgment, they had a regularization order, my lord. And because this respondent, my lord, he did not have the regularization order, that is why accountant general wanted us to see whether there was government approval for regularization or not. Then, my lord, subsequently we were advised by the department to file this review, my lord. And my lord, there are certain decisions also which say that review is, my lord, inherent power of this court. So, my lord, limitation as such does not apply.
You have a copy of that judgment is Sanjita Roy?
Yes, ma'am.
Mr. Ibot Thakur, learned counsel for the petitioner. None appears on call for the petitioners for the respondent. Next, Madam. It may be mentioned that notice on respondent number 1 was sent by registered post with AD, but neither the unserved notice nor the AD card was returned. So accordingly, the applicants were directed to serve notice by way of Dasti. By order dated 9/12/2024. Accordingly, the affidavit of the service of the affidavit of service by way of Dasti was filed on 14/2/2025. Full stop. In the meanwhile, in the meanwhile, Mr. J. Sharma and counsel prepared for the respondent and respondent on 3/1/2025, and as per the order passed on the said date, he had submitted that he had appeared after receiving verbal instructions and praised for some time to file affidavit in opposition and wakalatnama. Full stop. Thereafter, when the matters were listed on 12/2/2025 and 28/3/2025, the said learned counsel did not appear, and as per the office note, dated 2/5/2025, wakalatnama in respect of respondent was not filed till date. Respondent or affidavit in opposition was not filed till date. Next paragraph. Although there is a delay of 799 days beyond the period of within the period of limitation filing the connected review petition, but the learned counsel for the applicants has been able to demonstrate that there is no record of regularization of service passed against the respondent from pastoral worker in Ojai Division of Public Health Engineering to a regular service and therefore the ratio of Sanjita Roy versus State of Assam and others, WBC 1089 of 2015, decided on 4/12/2018. Would not apply for the petitioner, respondent. Under such circumstances, notwithstanding the inordinate delay in filing this interlocutory application for condoning the delay, this interlocutory applications, the prayer made in this interlocutory application stands allowed, and the delay of 799 days beyond the period of limitation in filing the connected review petitions stands condoned. Next paragraph. The registry shall now list the connected review petition.
Item 7.
There is no representation from the applicants. First of all, and Judge Justice, the matter stands adjourned today. List after a week. Yes, there's item 8.
Item 8.
You have seen that recording in the meanwhile?
My lord, done for that, my lord, what is stated is not, the accused is not a minor, my lord, what I have found, my lord.
It's not a minor.
She is a major, my lord.
In 8, somebody is there?
From the
No.
forwarding and my lord, other documents, it is
No.
stated
In
that
8, anybody is there for item 8? No.
No.
No representation from the petition. I just say matter.
Her age, that point of time was shown as 33 years during the
No,
time
no.
of incident, my lord.
But this,
But my lord, in the order, my lord, admitted.
if this order is
Yes, my.
that he was given bail
Yes,
on account of his
yes,
minority,
yes, my lord. That is the
then we-
learned PP also fairly submits that in view of the same, the bail application may be considered since the accused is a minor. Very
so
specifically.
this calls for
clearly
a,
mentioned,
calls for a suo motu revision.
my lord.
This can't be permitted. And
May I submit, my lord?
yes,
As per the order, first page, it has been mentioned. Vital witnesses were minor sons of the accused, Hiramoni Haloi.
no, you see the very basis on
In the
which
second
the
phase also
order
minor
is
sons.
passed is minor.
Inadvertently, minor word has been.
No, no. But you are now asking for parity by showing us that order, that the other co-accused has been released.
Then I may be permitted to withdraw. As per my contention is that considering the grounds of arrest is not mentioned, additional affidavit has been submitted. There is no grounds of arrest. I'm coming purely on grounds of arrest, Your Honor. In the meantime, bail has been allowed on 31/5/2025. If you Honor scan the grounds
No,
of
if-
arrest, there is no mention why I have been arrested, Your Honor. Only case number has been inserted.
We will issue a notice then, you respond to it.
My.
Because if you refer to that bail order, then we are asked, we are
We withdraw you.
referring
I
for.
may be allowed to withdraw. The bail order submitted by me.
We are already passed over there.
My.
Once you refer to it, then suo motu revision.
Thing is that my lord, Your Honor, my contention is that minor witnesses has been examined. So out of 7 witnesses, I have not been.
Issue a notice to the state. So they'll have to respond to this grounds of arrest.
We have annexed Bihan Kumar judgment passed by Honorable Apex Court.
Yes, sir. No, without issuance of notice, we can't allow this application.
OP to pass.
Additional
Okay, to nine, that is good. Yes, my. Bail.
Mr.
R. Boysu.
R. Bushu, the counsel for the petitioner. You should not issue notice on this application for bail. Mr. K. Bushu and APP accepts notice on behalf of this state.
My lord, here, my lord, this matter is for the hearing, my lord. At the hearing stage, only the thing is that
No,
my lord,
once
they have
you
filed
are
additional
taking a
affidavit.
ground of arrest, you'll have to respond to it.
Yes, my lord, there's additional affidavit newly filed by me. Yes. To that
Mhm.
effect, I have to respond.
You have to respond.
Yes, my lord.
Next para, by filing an additional affidavit, the petitioner projects that the grounds of arrest has not been served on the petitioner, and on this new ground, the present bail application has been filed. After that, issue notice to the state respond. Full stop. Objection, if any, be filed at least 1 day prior to the next date of listing. Next para list on. Last week is. Twenty-five, 6/2025.
Coming
Make it
25.
22, make it 22, 22. 22, 6.
22.
I look.
In item 8, you say. It is noticed that the name of the learned counsel for the applicant is not reflected in the cost title, the cost list, accordingly. On the next date of listing, the name of Mr. S. Day shall be reflected as learned counsel for the applicant while listing the matter next list week.
Okay, my